the aviation of the Republic of Korea. To bring the world closer, we embrace challenges in making airways and usher in great changes without stopping. ICAO was initiated by the Chicago Convention 80 years ago. As an ICAO member state, Korea has actively participated in global discussions on aviation standards and policies, contributing to the advancement of the aviation industry. Broadening global airways and making them safer, Korea bridges countless dreams together in cooperation with cities around the world. Ranking 8th in the world for aviation transport, Korea is working on multiple initiatives to overcome current challenges and secure a sustainable future for the aviation industry. Korean airports are innovative, convenient, and enjoyable, exceeding travelers' expectations. Incheon International Airport has become a key hub in Northeast Asia. With expansions to accommodate up to 100 million passengers annually, Incheon is en route to becoming a truly global mega-hub airport. With Smart Pass facial recognition immigration services, the airport's advanced infrastructure continues to become smarter than ever through ICT services. We share our innovative achievements and experiences with others to flourish together. SMIS, Standard and Recommended Practices, Management and Implementation System, SOMS, Safety Oversight Management System, is applicable for various supervisory environments. Korea contributes to developing and disseminating critical aviation safety IT systems. As a leader in aviation workforce education and development, Korea fulfills its responsibilities as a member state by continuously implementing ICAO's No Country Left Behind initiatives. The future of aviation will evolve in tremendous ways, and such changes require a strong sense of duty as well as innovative measures. To protect the planet, Korea proactively prioritizes eco-friendly operations and reduction of carbon emissions through rigorous implementation of ICAO's CORSIA. Korea is also strengthening the development and usage of sustainable aviation fuel produced from alternative energy sources. By participating in the Renewable Energy 100% initiative and utilizing 100% renewable energies, Korea contributes to creating cleaner, bluer skies. Our automated X-ray detection system uses artificial intelligence to enhance the detection and analysis rate of hazardous materials. Our UAM technology aims to analyze transportation demand via AI to ascertain safe and efficient routes for autonomous flights. Korea plans to commercialize UAM by 2025, boldly embracing current challenges and advancing future aviation. It hasn't been a long journey for us, but we've accomplished countless remarkable achievements. What exciting changes lie ahead of us? Dreams soar freely in great blue skies. We are ready for the skies of tomorrow. I am the aviation of the Republic of Korea.
Well, esteemed delegates, distinguished guests, and ladies and gentlemen, welcome to the 2024 ICAO Legal Seminar with me, Shinji-e, as the MC. Well, this seminar is hosted by the International Civil Aviation Organization as well as the Korean Ministry of Land, Infrastructure, and Transport. Today, we are joined by more than members from 92 countries, including the ministers and the vice ministers of aviation from 6 countries. And so thank you very much, all of you, for being here with us despite of the great distance. During the seminar, we will be sharing the insights as well as the experiences to explore how we can expand this partnership with the global aviation stakeholders and incorporate the international regulations into the national laws more efficiently. Well, before we embark on this interesting journey together, I would like to inform you that today's seminar is a paperless seminar that all the presentation materials can be downloaded through the QR code that has been printed at the back of your name tag. So, having said that, let us begin today's gathering by first welcoming to the stage Mr. Juan Carlos Salazar, the Secretary General of ICAO, to deliver his opening remarks. Ladies and gentlemen, let's welcome him to the stage with a big round of applause.
Excellency Won Kook Baek, Vice Minister of Land, Infrastructure, and Transport of the Republic of Korea, dear Ministers of Civil Aviation gracing this event, Directors Generals of Civil Aviation, the Presidents and Secretaries of the Regional Aviation Commissions, ICAO Council representatives, distinguished colleagues and ladies and gentlemen, I would like to express first my sincere gratitude to the government of the Republic of Korea for hosting us in this ICAO Legal Seminar 2024. Since 2006, the Republic of Korea has hosted 7 editions of the ICAO Legal Seminar, and over the past years, it has become a landmark event for the international air law community. The seminar began live as an event for the Asia and Pacific regions, but has now evolved into a global meeting for all member states. I am delighted to welcome today participants from 93 member states from various ICAO regions attending in person or following this seminar online by live streaming. This year's seminar is held amidst 2 remarkable anniversaries for ICAO and for the global aviation community. We are marking both the 80th anniversary of the Chicago Convention and also the 75 years that have passed since the adoption of Annex 9 on facilitation. For 80 years, the Chicago Convention serves as the most successful and important international legal instrument in aviation and proved how a whole industry can advance by spectacular leaps through well-established treaties. Each of its annexes are crucial and very important to the safe, secure, and sustainable development of air transport and its crucially important ability to act as a catalyst for growth. In the Convention, states agreed on certain principles and arrangements in order that international civil aviation may be developed in a safe and orderly manner, and that international air transport services may be established in the basis of equality of opportunities and operated soundly and economically. And the international air law fostered by ICAO provides the foundation for this. In this context, we have designated 2024 as the year of facilitation. Accordingly, the importance of the rule of law and the role of lawyers in this regard is fundamental for the aviation community and contributes enormously to the success of the sector. Meetings for this community of professionals, to which I also am part of, strengthen cooperation and the exchanges of views. Discussions on important subjects of legal interest are highly beneficial, particularly as ICAO and its member states progress work in anticipation of the 39th session of the ICAO Legal Committee to be held in June 2024, and also the 42nd session of the ICAO Assembly next year. I look forward to welcome you all, both at the ICAO Legal Committee meeting, but also at our coming ICAO Assembly. Indeed, the organization of this seminar and your participation here serves the objectives of Assembly Resolution A41-4, in which the ICAO Assembly acknowledged the important role of the civil aviation legal advisors and the legal practitioners, as well as encouraged member states to make use of seminars, workshops, and courses and other similar events for the continuous training and development of their legal advisors, and to consider hosting these events from time to time. On the program of the legal seminar this year, there is a wide range of topics in the legal field. Some of them are on the work program of the Legal Committee of ICAO and will be discussed more formally, such as the review of the ICAO rules for the settlement of disputes or the ratification of key international air law treaties. Others are emerging new topics, such as the new air mobility discussions. Let us take the Chicago Convention's anniversary this year as an important opportunity to advocate for the continuous development of our legal instruments and for their wider ratification. I wish to underline that the 2016 protocols amending Articles 50A and 56 of the Chicago Convention, with a view to enlarging the membership of the Council and increasing the size of the Air Navigation Committee, are not in force yet due to insufficient state ratifications. The 41st session of the Assembly recommended to all contracting states to ratify these protocols most urgently. Among the priorities for actions that I am sharing with you today, this is therefore the first that I would like you to consider. I wish to stress that continuous efforts are made by the ICAO Legal Affairs and External Relations Bureau for the promotion of the ratification of international air treaties. And I encourage you all to make further efforts in order to reach our common goals. Your leadership in this area is essential. Indeed, the challenges we face reaching these goals are significant, but the opportunities for positive change are even greater when we work together. In this regard, ICAO is well aware that our global influence is measured by how widely and effectively our standards, policies, strategies, plans, and other guidance materials are addressed and implemented by regulators worldwide. We also know that a technically sound standard that cannot be effectively implemented by all states represent significant challenges to a harmonized and interoperable air transport system. These are some of the reasons why ICAO is working to enhance the delivery of implementation support services and products, and better plan and integrate the related requirements into every stage of a new or an amended standards development. Achieving this will increase our agility and allow us to be much more responsive in integrating new entrants and the cutting-edge innovations that we are presencing today. Delivering international standards more effectively and efficiently will allow our member states to benefit more quickly from innovations in operations and technologies that promise to transform our sector. Our vision is that by 2027, ICAO will have transformed into a modern, digital, adaptive, and collaborative organization demonstrating operational excellence. ICAO will be a results-driven organization focused on its people with a transparent, accountable, efficient, and value-driven culture that applies an innovative and agile approach in collaboration with key partners and other stakeholders to deliver an enhanced service for our member states. I would like to highlight that ICAO's upcoming new long-term strategic plan will draw on the current needs and future expectations of the various stakeholders and on analysis of the opportunities and challenges lying ahead for the civil aviation system. The significance of our commitment to serving you as member states and international aviation community better is the second point that I would like you to keep in mind at this seminar and beyond. Now, I must highlight the climate emergency. ICAO is stressing the fact that aviation's ability to respond to this tremendous challenge depends on the cooperation and commitment of all actors from across the air transport sector, lawyers and legal experts included. A fundamental aspect of ICAO's work on climate depends on upholding our rules-based system under the Convention, which helps ensure the critically important environmental standards in Annex 16 that are promptly and fully implemented by all member states. Over the last few years, ICAO environmental standards have significantly developed in line with emerging priorities. Indeed, all 4 volumes of Annex 16 were most recently amended in July 2023. Helping ensure effective and complete implementation of these standards is a primary priority for ICAO, for our member states, and of course for our legal bureau. Accordingly, as a third and final key priority for today, I would like to encourage you all to reflect on how you can support ICAO's climate advocacy within your respective organizations and countries, particularly in matters related to the implementation of these standards. In concluding, I wish to thank the government of the Republic of Korea once again for its long-standing commitment and for the consistent and comprehensive support for ICAO's work. I encourage participants to take full advantage of the seminar, and I wish you all a very successful event. Thank you very much.
Thank you very much, Secretary General, for your welcome remarks. As he have mentioned, this ICAO legal seminar started off at 2006 and now is in its 7th edition and became a landmark event for the global aviation community thanks to all of your support. So as the Secretary General have emphasized, everyone's role is indeed important for growth. And now moving on, I would like to invite Mr. Won-Kook Baek, the Vice Minister of Land, Infrastructure and Transport of Republic of Korea, to give his welcome remarks. Let's welcome him to the stage with a big round of applause.
Carlos Salazar, the Secretary General of ICAO. Honorable Chandra Gurung, Minister of Infrastructure and Transport of Bhutan. Honorable Jacob Hara, Minister of Transport and Public Works of Malawi, Honorable Jasim Saif Al Sulati, Minister of Transport of Qatar, Honorable Alba Romanus Baptiste, Minister of External Affairs, International Trade, Civil Aviation and Diaspora Affairs of St. Lucia, Honorable Serenity Tumor, Minister for Infrastructure of Tonga, Honorable Roberto Cecilio, Undersecretary of the Department of Transportation of the Philippines, President of ICAO, Secretary General of LACAO, Director General of Civil Aviation Authority, representative to ICAO, and distinguished guests. It is my great pleasure and honor to host the 7th ICAO Legal Seminar in Seoul, Korea. I would like to extend my warmest welcome to you all. ICAO Legal Seminar has been held in Korea every 3 years since 2006. At first, the seminar aimed to discuss legal issues related to the Convention on International Civil Aviation, also known as the Chicago Convention. It has now become one of ICAO's major conferences covering various global aviation issues such as aviation safety, security, climate change, and future aviation, reflecting changing demands on the aviation industry. Since the Chicago Convention was signed in 1944, the aviation industry has evolved with a steadfast growth momentum, connecting people and goods around the world. With connected wisdom, the industry successfully surmounted the unprecedented global health crisis, COVID-19, and is now heading toward a new future through transformation and innovation. In particular, new technologies, including AI, advanced air mobility, and remotely piloted aircraft system are drawing global attention as a powerful growth engine for innovation of the aviation industry. However, we should not underestimate the importance of environmental sustainability, as even groundbreaking innovations would be of no use if sustainability is not ensured. Therefore, this seminar will address not only the Chicago Convention, but also innovation in aviation, such as new air mobility and green technology to resolve climate change, all of which are at the center of global aviation dialogues. Global discussion on these topics help us to envisage future global aviation and ways toward. I expect that today's seminar will provide us an opportunity to contemplate major challenges and aviation issues from the legal perspective and offer insight toward through in-depth discussion and active information sharing. I also hope it will contribute to the implementation of ICAO's strategic objectives, including aviation safety, security, air navigation capacity and efficiency, and environmental protection, and foster joint commitment and support for orderly and sustainable development of international civil aviation. I firmly believe that our efforts to effectively incorporate innovative technology into the existing aviation system and advanced international aviation law based on the Chicago Convention will definitely lead us toward more prosperous future aviation. Distinguished guests, as the 10th largest trade powerhouse and the 8th biggest air transportation country in the world, Korea has worked together with the ICAO and the member states for the development of global civil aviation. We promise to continue to faithfully fulfill our role and responsibility as an ICAO Council member. I hope 2024 ICAO Legal Seminar will be a great chance for the aviation community to explore ways to future advance the industry and reaffirm partnership. Once again, I would like to expand my sincere gratitude to ICAO's Secretary General Salazar, ministers, presidents, and Secretary General of Civil Aviation Commission, and all participants for gracing us with your presence. Spring is in full bloom here in Korea. Just like a new sprout growing from the ground with great vitality and energy they collected during cold and harsh winter. I believe the global aviation community can go further if we fly together with collective efforts. In closing, I hope all of you have a meaningful and memorable time during your stay in Korea, and wish you a good health and happiness. Thank you very much.
Yes, thank you very much, Vice Minister Won Guk-baek, for the welcome remarks. As he have mentioned, well, this seminar is going to be a great opportunity for all of us, where we will be having a deliberate discussions on the pending issues. So let us use the given time wisely in order to seek our ways forward. So, in order for us to fly together in collaborative effort, moving on, I would like to invite to the stage His Excellency Alba Romanus Baptist, the Minister of External Affairs, International Trade, Civil Aviation, and Diaspora Affairs of St. Lucia, to deliver his remarks. Let's welcome him to the stage with a big round of applause.
Thank you very much, Madam Chair, for your kind and generous introduction. Before I get down to business with my brief intervention this morning, I would like to acknowledge the Vice Minister for Land Infrastructure and Transport, Won Guk-baek, other distinguished ministers, the Secretary General of ICAO, and other staff members, representatives from international organizations, decision makers from aviation service providers, executives from financial and development institutions, sponsors of this event, other distinguished personalities of this august assembly, ladies and gentlemen. This morning, I am clothed with the important trust of delivering congratulatory remarks at this year's 2024 ICAO Legal Seminar, a seminar which is charged with invaluable significance. But, Madam Chair, as I taxi for takeoff, I beg leave to extend greetings to you all on behalf of the government of St. Lucia. Chair, as I look into memory's eye If I am seeing properly, this ICAO legal seminar, co-hosted by the hospitable government of the Republic of Korea, has been held triennially since 2006 and has distinguished itself as an exemplary and important forum for meaningful engagements on key international aviation policies and strategies and promoting cooperation, collaboration, and networking opportunities amongst ICAO member states. It is truly an opportunity, Madam Chair, for participants to discuss and exchange ideas in an atmosphere predicated upon the cross-fertilization of ideas. In this regard, human tongue has no word to assist me in thanking the government of the Republic of Korea for the excellent arrangements made and for providing the conducive environment for the successful hosting of this 2024 ICAO legal seminar. This seminar provides an opportunity to engage in profound and insightful discussions on two critical facets of global aviation: sustainability and facilitation. Chair, we cannot evade the objective reality that the sustainability of a dynamic aviation industry requires a comprehensive consideration of the legal architecture underpinning the aviation industry and the need to adopt innovative legal approaches. Consequently, commendation and approbation are quite in order, both ICAO and South Korea, for illuminating the centrality of a robust legal infrastructure in this regard. And two, the ICAO Council has named 2024 as a year of facilitation, with a central focus on emphasizing the importance and transformative potential of air transport facilitation. This seminar has accentuated its tremendous significance, given that we need to review our laws to improve and enhance facilitation in air transport. We must remove all encumbrances as we work assiduously toward this goal. As member states of ICAO, we need collectively to engage in a common and conscious endeavor to continually review and update the standards and recommended practices contained in Annex 9 as we seek to address the challenges and embrace the opportunities of the evolving landscape of air transport, advances in technology, and the value of contributing to the development of international civil aviation. The benefits of facilitation cannot be realized without a sound legal framework, because even the best policies could be frustrated by poor legislation. According to ICAO, air transport facilitation can be linked to 9 of the 17 Sustainable Development Goals set forth by the United Nations. We cannot therefore overemphasize the important role played by the International Civil Aviation Organization in facilitating air travel, given its critical importance in global development and the extensive socioeconomic benefits it brings to our respective member states. This legal seminar aligns strategically with the essence of the ICAO's 2024 theme and provides us with the opportunity to positively contribute to the goal of improving air transport facilitation. We are indeed privileged to have in our midst policy and decision makers at this seminar who can agree on the central policy decisions, who can take decisions within our respective domains on air transport facilitation, policy proposals that would instigate concrete responses within the decision-making bodies of our individual states. However, it is important to note that effective policies and facilitation must consider the legal implications with our regional and international counterparts. I am sure that we can all agree that this ICAO seminar today in the Republic of Korea will assist tremendously in providing us with the necessary motivation and commitment to ensure that our policies and legislation are in consonance with appropriate mechanisms to facilitate air transport. I wish to note that while international air services agreements are embraced principally as an economic regulatory undertaking, these agreements are an important element in international facilitation considerations at the global level. As is well established in the literature, facilitation should be considered both from a micro and macro level. In this regard, we need to ensure that all stakeholders are fully aware of and accept their respective responsibilities to realize the common goal of efficient and seamless travel experiences for all, so as to continue to make air travel the safest mode of transport. As I prepare for landing, I acknowledge that this fundamental undertaking could not have been realized without the many sponsors and other supporters. We are indeed grateful for your contribution to this event, and I say, without any fear of contradiction, that your commitment to the global safety and harmonization assignment, promoting cooperation and collaboration amongst ICAO member states, is indeed pellucid. In closing, I wish on behalf of all ICAO member states, including my country, St. Lucia, to congratulate the International Civil Aviation Organization for this very important initiative, along with the Ministry of Land Infrastructure and Transport of the Government of the Republic of Korea for co-hosting this invaluable, well-organized event. Congratulations to all. Chair, I now yield the floor. Thank you.
Thank you very much, Minister, for your remarks as well. You have emphasized the significance of today's seminar, in which we should take full advantage and engage in conversations moving forward. And he has also emphasized that everyone's commitment is indeed important. And now moving on, it is my pleasure to invite to the stage Mr. Alessio Quaranta, the president of ECAC, to deliver his remarks. Let's welcome him to the stage with a big round of applause.
Your Excellency, Vice Minister, Your Excellencies, ICAO Secretary General, Excellencies Ministers being here today, distinguished delegates, dear colleagues, in my capacity as President of the European Civil Aviation Conference and on behalf of its 44 member states, it is an honor and a privilege to participate in this year's ICAO legal seminar co-hosted by the Ministry of Land, Infrastructure and Transport in partnership with ICAO in the beautiful town of Seoul. Every 2 years, this event brings together experts from around the world to discuss and review the most recent developments in international aviation law. And this is a really valuable event for all of us. In the next 2 days, we will have the opportunity to receive expert updates on current subjects, both in the field of international air law and also on ICAO's work on current topics in aviation law and practice in different domains such as safety and facilitation. I wish to thank the Minister of Land, Infrastructure and Transport for its leadership in this domain. The Chicago Convention and all the other legal instruments of civil aviation, such as the Tokyo Convention and the Cape Town Convention, shape the framework in which our aviation ecosystem can operate safely and securely and help it grow for the benefit of our economies and citizens. The legal certainty and stability that such legal instruments bring to our sector are invaluable. They are critical to a sector that by nature is truly international. Without such a solid legal framework, we would not be able to operate effectively. For the reason, the ratification of legal instruments need to be a priority, and the respect of the rules of law is fundamental for us. I would like to take this opportunity to recognize the remarkable work done by the ICAO Legal Committee and its different working groups, in particular on complex issues such as Article 3 bis and Article 84. The committee work is also essential to shape the current and future legal framework of civil aviation, for example, on the topic on unmanned aircraft systems, and I look forward to the outcomes of this next meeting in June. To conclude, as a legal expert myself, I really look forward to our discussion in the next days, and I wish you a very fruitful and productive seminar. Thank you very much.
Thank you very much, President Alessio Quaranta, for your remarks. Well, as he have mentioned, recent developments in the global aviation industry will be mentioned along the way here at the seminar, which will be held from today until tomorrow. And as this is a rare opportunity for all of us, I would like to now spare the time to have a photo session with the distinguished guests. We will be having 3 photo sessions overall. For the first session, I would like to invite the guests at the first row, starting with all the ministers from different countries, as well as Secretary General of ICAO, and also the President and the Secretary General of the Civil Aviation Community. So please join us on the stage for the first photograph. All right, ladies and gentlemen, I guess we're now ready to begin our first session here at the 2024 ICAO Legal Seminar. The first session is titled ICAO's Work in Legal Field, and this will be led by Mr. Michael Gill, Director of Legal Affairs and External Relations Bureau at ICAO, and also joined by Mr. Andrew Opalot, the Legal Officer of Legal Affairs and External Relations Bureau at ICAO. Let's welcome both of the speakers to the stage with a big round of applause. Yes, for this session, we are to welcome Mr. Michael Gill, the Director of the Legal Affairs and External Relations Bureau at ICAO. And also, another speaker that will join us is, yes, Mr. Andrew Opalot, the Legal Officer of Legal Affairs and External Relations Bureau at ICAO. Is the 2 gentlemen here in the room? Yes, please join us on the stage. And as we have both gentlemen on the stage, we will begin the first session. Yes, why don't we welcome both of the gentlemen again with a big round of applause. And of course, for the first presentation, we're going to have Mr. Michael Gill on the podium to have the presentation. So, sir, please.
Thank you very much for that warm welcome. Good morning, ladies and gentlemen, excellencies, distinguished ministers and representatives to ICAO. Dear colleagues, it's an absolute honor and a pleasure for me to be here with you this morning. And I do want to start by thanking our colleagues at the Ministry of Land, Infrastructure and Transport of the Government of the Republic of Korea for the invitation to be here and for their extremely generous welcome and the strong support that they've given to ICAO in the organization of this event. As has been said, the legal seminar has now been running into its 7th iteration, and the event continues to go from strength to strength. You can see the level of interest for this meeting by the number of us here in the room and also joining online. And I think it's a testament to the support and the investment that the government of the Republic of Korea have given to this event and to the activities of ICAO in the legal field generally. So it's a real pleasure for myself and the rest of my colleagues from the Legal Bureau to be here with you, and we're looking forward to spending time with you in the coming days. What my presentation is intended to do really is give an overview of the activities of ICAO in the legal field, particularly since the last session of the ICAO Assembly in September and October of 2022, and the work that that has been undertaken in the last 2 years as we prepare for the next session of our legal committee in June of this year in Montreal, as well as the following 42nd session of the Assembly in the autumn of 2025. So what I'm going to cover are an overview of ICAO's policies in the legal field, the background and current activities of the legal committee and our work program. I wanted to say a few words on the issue of the settlement of disputes by the Council of ICAO, as that's becoming an area of particular focus, and then hand over to Andrew Opolot to move forward with his part of the presentation. Now, just by way of background, there are many ICAO experts in this room, many people who've worked for a number of years with ICAO, but for those who are not familiar with the organization, just a few words of introduction. ICAO is a UN specialized agency. We were created by the Chicago Convention, which was adopted on the 7th of December 1944. Interestingly, the Chicago Convention was adopted before the end of World War II and indeed before the adoption of the UN Charter. Now, the Convention provides not just the constitution of the organization itself, but of course also sets out a whole range of substantive rules governing international civil aviation. But the Convention's only been amended twice as far as the substantive rules governing international civil aviation are concerned. And I think that really demonstrates that the basic principles governing international civil aviation have remained largely unchanged since 1944. We today have 193 member states. The last member state who joined was Dominica in 2019. And as the Secretary General noted earlier, this year marks the 80th anniversary of the adoption of the Chicago Convention. It's a significant milestone. I think, bears witness to the strength of the drafting of the Convention itself, as well as the commitment to our member states, to our organization over those 80 years, and a number of events will be taking place in the course of 2024 to mark that. The ICAO Assembly defines the strategic objectives for each triennium, and currently the strategic objectives of the organization are shown on this slide. Aviation safety, aviation capacity and efficiency improvements, enhancing civil aviation security and facilitation, and we heard earlier that this year is also the 75th anniversary of the adoption of Annex 9 to the Convention on Facilitation. A further strategic objective, of course, is fostering the development of a sound and economically viable civil aviation system. And then finally, to minimize the adverse environmental impacts of civil aviation activities. Now, again, as the Secretary General noted this morning, there is work underway at the moment to review those strategic objectives and ensure that they're fit for a purpose for the coming decades of the organization. And one of the areas which we're looking at is whether to include the rule of law, strengthening the law and the legal system governing international civil aviation and our rules-based system as a strategic objective for the organization itself. And those discussions are ongoing within the Secretariat and, most importantly, within the Council. So that's the overall strategic plan for ICAO. But specifically in the legal field, the ICAO Assembly defines the policies of the organization, and in the legal field, those are contained in Assembly Resolution A41/4. Essentially, that is a consolidated statement of ICAO's policies in the legal field, and it is updated at every session of the Assembly, but essentially sets out what ICAO's policies are. And so, for example, that resolution I mentioned reaffirms the important role of law in the avoidance and resolution of conflicts and disputes amongst the nations and peoples of the world. There are other three specific appendices to that resolution which I think are important to note also. Appendix C to our consolidated statement deals with the ratification of international air law instruments, and the next presentation by Andrew Opolot is going to address that very topic. Essentially, through that Assembly resolution, all states are called upon to consider becoming parties to the various ICAO air law treaties. Appendix D of our consolidated statement deals with the teaching of air law. It's a really fundamental activity for ICAO. Essentially, we as a Secretariat have been directed by the Assembly to take any possible actions not only to promote the teaching of air law, but to promote the dissemination of the knowledge of air law all around the world. And I think it's a really crucial activity to encourage the next generation of aviation professionals and aviation law professionals in particular. Appendix G of our consolidated statement deals with enhancing the capacity of states to implement air law treaties and to update national laws and regulations. And that aspect of the resolution really confirms the important role that civil aviation legal advisors and air law practitioners generally play in supporting states and the industry in implementing international air law treaties, updating national laws and regulations to give effect to national policies. Interestingly, the resolution asks for member states to support the work of ICAO in enhancing the capacity of the civil aviation legal advisors in our member states, and that's a very important part of our work. And events like this, I think, really support that. Now, turning to the ICAO Legal Committee itself, the Legal Committee was established in 1947 by the first ever session of the ICAO Assembly, and it's open to all member states. It's not a committee of limited membership. The committee is somewhat unique in the overall ICAO governance because it's a body that was created neither by the convention itself nor by a decision of the Council. It was specifically established by the first session of the ICAO Assembly. But as I said, participation is open to all member states. The committee meets as and when necessary, when there's a specific decision that needs to be taken or a specific piece of work which needs to be reviewed. But generally speaking, over its history, the committee has met once every 2 years. In our mandate of the Legal Committee, there are various specific functions advising the Council on the interpretation or of any amendments necessary to the Chicago Convention, making recommendations on matters of public or private international air law, preparing drafts of international air law treaties. And on that point, it should be noted that the Legal Committee in its existence has contributed significantly to the development and the unification of international air law. Under the committee's auspices, some 24 international treaties have been prepared in the fields of aircraft finance, airline liability, and aviation security. And so the Legal Committee will continue to play that strong role in the development of international air law. Now, what do we have on our work committee? The work program of the Legal Committee is defined by the Council, and we currently have 8 items, and you'll see them on this slide in the order of priority. Tomorrow you're going to have a full briefing on item number 1, which is the review of the rules for the settlement of differences, so I won't go into that particular topic in too much detail. In a moment I'll talk about the function of the settlement of differences generally, by the ICAO Council, but the progress on the review of the rules will be briefed tomorrow. But just to say a few words on the other top priority items, 2, 3, and 4, which I think will give you a flavour of the work currently underway within the Legal Committee. As I said, our upcoming next session of the Legal Committee will be from the 25th to the 28th of June in Montreal, and the committee essentially will consider the items on the work programme, but in order of priority, with more focus given to the top priority items. I did want to say that at the end of this session of the Legal Committee, we will elect a new chair and a vice chair who will serve for 2 sessions of the committee. And I think it's an appropriate point in time to recognise the significant contribution of the current chair of the Legal Committee, Ms. Sue Hei Tan from Singapore, who has served in that position since September of 2018. Sue Hei Tan will be appearing on our programme tomorrow and is well known to many of you, but she has made a huge contribution to the work of the organisation, a huge contribution to the ICAO Legal Committee and to the cause of international air law generally, and so we all owe her a huge debt of gratitude. What about the substantive topics then on the Legal Committee agenda? I just wanted, as I said, to mention a handful of them. Our top priority item 2 relates to the legal aspects of unmanned pilotless aircraft, and there will be a specific panel discussing that topic at this seminar tomorrow. As you may be aware, the framers of the Chicago Convention recognized even then, some 80 years ago, the potential for the emergence of new technology, and there is already in the Convention, in its Article 8, a provision dealing with pilotless aircraft. That issue was then included on the work programme for the Legal Committee in 2013, because I think it was recognised that pilotless aircraft, RPAS, drones, UAVs, however you want to term them, were developing at a rapid pace, and it was important that the legal framework kept up with the technological and operational developments. And so the Legal Committee at that time established a working group, and essentially the key legal topics to be addressed are looking at the international legal aspects of pilotless aircraft operations and how they should be integrated into the civil aviation system, identifying items for consideration and possible legal solutions within the framework of ICAO's ongoing work, looking at legal measures to support the implementation of the international regulatory framework which is necessary for a pilotless aircraft, and then looking at legal issues arising from newly emerging unmanned pilotless aircraft technology systems and applications like unmanned aerial taxis, the carriage of cargo, and related liability concerns. So that work is ongoing. There is, as I said, a working group of the Legal Committee which has set up 2 subgroups, and we look forward to hearing reports from those groups at the upcoming session. And as I said, tomorrow there will be a specific panel in this seminar looking at new mobility challenges and the aviation legal perspective. Another item on the work programme of the committee relates to Article 12 of the Chicago Convention. As you may be aware, under Article 12, the state of registry of an aircraft is responsible for ensuring that the aircraft complies with the rules and regulations relating to the flight and manoeuvre of aircraft in force wherever such aircraft may be, and the prosecution of all persons violating those rules and regulations. Since 2019, this topic has been on the work programme of the Legal Committee. The overall objective is to undertake a study of the current implementation of Article 12 by Member States, as well as to identify the means and the mechanisms for states to support and enhance implementation. So the main output we're looking for on the topic of Article 12 is to develop ICAO rules or guidance recommendations aimed at assisting states to enhance the implementation of their obligations under Article 12, the terms of which aren't noted on this slide. The committee is also looking at the development of a mechanism which would allow for the timely exchange of information between states following a violation of the rules of the air in order to support compliance with the obligations under Article 12. And perhaps that mechanism will take the form of a web portal for the exchange of information between states. But it's a key piece of work that the Legal Committee and the relevant task force is undertaking. We issued in December of 2022 a survey to Member States. The main purpose was to elicit responses concerning the existing mechanisms and measures and challenges for states in performing these obligations under Article 12. And you'll see on this slide the split in the percentage of states that have established laws or regulations for the implementation of Article 12. Some 86% have established laws and regulations regarding prosecution for violations of the rules of the air, and you'll see the other split of the responses to the questions that survey elicited. So the committee will consider at our upcoming session progress on the work that's been carried out by the task force so far, and then potential next steps in that work. The other area on the work programme of the Legal Committee I wanted to mention relates to acts or offences, including cyber threats that may not be adequately covered by existing air law instruments. Now, of particular concern here is the implementation of the Montreal Protocol of 2014. This relates to the legal aspects of unruly and disruptive passengers, which can have a direct relation to cyber threats. And there's been a lot of work going on within ICAO on this topic. In 2019, we published the manual on the legal aspects of unruly and disruptive passengers, and since then we've continued to monitor and respond to inquiries relating to the Montreal Protocol of 2014. You're going to hear more detail on the promotion of the Montreal Protocol of 2014 later on in this seminar, but it's an important development in protecting international aviation security. We should also note, with regard to the cybersecurity aspect, that ICAO continues to promote the Beijing 2010 instruments, which many of you will be aware of. Those have a specific application to cyber attacks against civil aviation, are important international air law instruments which we need to continue to promote. So those are items currently on the work programme of the Legal Committee, and which will be discussed at our next session. Now, there are 2 points which are not on the work programme, but which may well end up there, which I did want to mention. Firstly, relating to the Convention on the Marking of Plastic Explosives adopted in 1991, the famous MEX Convention. Just by way of background, the MEX Convention was adopted following a series of major air disasters in the 1980s, Air India in 1985, and the Lockerbie Pan Am disaster in 1988, where explosives were found to have been placed on board aircraft, evading detection by the screening processes which were in place at that time. Now, during the most recent session of the Council in March of this year, the Council has requested that the implementation of the Convention on the Marking of Plastic Explosives should be considered by the Legal Committee at its next session. The reason for it is quite simple. Under the Convention, the Convention establishes a commission to evaluate technical developments relating to the manufacture, marking and detection of explosives. And that commission is appointed every 3 years by the Council, and the commission is entrusted with proposing amendments to the technical annexes to the MEX Convention. However, over the years, the work of the Convention has somewhat lost its relevance because technology and methods for screening have advanced, enabling a detection of plastic explosives by other means. So on the one hand, there is an obligation on the Council to proceed with the nomination of the Commission, but in reality, the work of that Commission has largely been overtaken by technology developments and does not have any particular purpose. So we're appointing a Commission which has a limited scope and purpose. And so the Council has asked the Legal Committee to consider looking into this issue so that the committee can either undertake an evaluation of potential solutions as to whether an amendment is required to the Convention in order to redefine the roles and the functions of the Commission, or alternatively to terminate the functioning of the Commission on the basis that it's fulfilled its initial mandate. So that will be a topic raised at the Legal Committee. Another issue which is not yet on our work programme is that relating to data protection and international carriage by air. This is a topic of key concern to the industry, and I'm delighted that you'll hear more on this from my colleague Leslie McIntosh, representing the International Air Transport Association, IATA, and the airlines, and she'll highlight exactly why this is such a topic of such concern for the sector. We held a joint seminar with IATA in September of 2023, really just to highlight the complexity of existing national data protection laws and the importance of protecting personal data when it's transferred across jurisdictions. Now, in the past, a lot of ICAO's work in this area has related to API, Advanced Passenger Information Data, and PNR, Passenger Name Record Data, which is addressed in Annex 9. But we are understanding that this issue is of broader concern and needs a more holistic view. So this is an issue which we'll hear more from the industry and indeed which the Legal Committee will give consideration to. So as you can see, we have a pretty full agenda for our June session, but there are many interesting and varied topics that the Legal Committee will consider. Moving on from the Legal Committee itself, I did want to say just a few words about the settlement of disputes function by the Council of ICAO. As I said, my colleague Yao Nyampong tomorrow will go into a lot more detail about the process of revision of the rules of procedure for the settlement of disputes. But briefly, I wanted to mention what the function of dispute resolution by the ICAO Council relates to. Article 84 of the Chicago Convention essentially entrusts to the Council a function in the settlement of disputes between contracting states. Under that provision, any disagreement between two or more contracting states relating to the interpretation or application of the Convention or its annexes that cannot be settled by negotiation shall be decided by the Council on the application of any state concerned in the disagreement. Decisions of the Council under Article 84 may be appealed to the International Court of Justice, or, if the parties can agree, to a separate arbitral tribunal. Now, we do have a set of rules, a separate set of rules of procedure for when the Council is seized of a case under Article 84, but those rules were adopted in 1957, and as I said, there is a process in the Legal Committee underway to review and update those rules of procedure. Now, within the whole of ICAO's history, we've only had 12 cases brought before the Council for consideration under Article 84, and in none of those cases has the Council actually had to rule on the merits of a dispute, because all of the previous disputes have been settled through mediation or negotiation relying on the good offices of the President of the Council. But since 2016, we've had 6 cases presented to the Council, 3 very recent cases which you'll see on this slide, which have been filed since 2022, Australia and the Netherlands and the Russian Federation in 2022, which relates to the downing of flight MH17 in July of 2014. And then in February of in October of 2023, the Russian Federation and 37 member states relating to allegedly unlawful and unilateral restrictive measures imposed against the Russian Federation in violation of the Convention. And then in January of this year, a matter referred by Canada, Sweden, Ukraine, and the United Kingdom against Iran relating to the downing of flight PS752 in January of 2020. And we understand that another case will shortly be received by the organization under Article 84. Now, I wanted to mention, because as I said, this is the level of activity under Article 84 matters has increased significantly. It shows that states are, I think, increasingly seeking the avenue of Article 84 as a means to resolve aviation disputes. I also think, frankly, that shows the confidence that our member states have in the robustness of the Article 84 mechanism. They recognize that there is a way for them to resolve disagreements through the Council, while still allowing the crucial work of ICAO and the rest of its fields of activity to continue. And so I think this increasing use of Article 84 is a good demonstration that our states have full confidence in the robustness of that mechanism and its ability to bring solutions to disagreements that they may have. As I draw to a close, I just wanted to highlight one thing which many of our states may not be aware of. There is a portal on our secure ICAO website, which is administered by the Legal Bureau, and it contains a lot of very important information allowing contact between states and ICAO on safety and other aviation matters. A number of states have included on that page information about the respective legal advisors in the states, and we're encouraging all of our member states to submit and keep the information in that portal up to date. If you need any further information on that, please don't hesitate to reach out to one of the Legal Bureau or the Legal Bureau address in Montreal. So let me conclude again. Thank you for your attention to this presentation on the work of ICAO in the legal field, what we've been trying to achieve since the last session of the Assembly, and anticipating the upcoming 39th session of the Legal Committee in June. We hope to see many of you in Montreal in June for what we hope will be a successful Legal Committee meeting. I wish all of you a very productive seminar. I wanted to close in thanking again our hosts in the Government of the Republic of Korea, all of our sponsors, but particularly to all of you for your participation, your kind attendance, and we look forward to the interaction with you in the coming 2 days. Thank you very much for your attention.
Yes, thank you very much, Mr. Michael Gill, for the presentation. He has talked about the progress over the last assembly and what we can expect this June at Montreal. And of course, he went over the ICAO's strategic objectives as well as the work programs and the policies in the legal field. Moving on, we would like to invite Mr. Andrew Opolot to the podium for his presentation. Let's welcome him with a big round of applause.
Good morning, all. I would like to thank the Ministry of Land, Infrastructure and Transport of the Government of the Republic of Korea for the invitation to be here today. This is my third visit to Korea since 2015 to facilitate at this event, and it's therefore a great honor to be invited again. Samita. The ministers and the Secretary General this morning all emphasized the importance of states jointly seeking positive change, and treaties represent the best example of nations coming together to forge consensus towards a common objectives when they adopt treaties in a spirit of give and take. The world needs to see this universal approach followed also in the process of ratification and implementation of the adopted treaties. As has been emphasized, a unified global legal framework contributes to the orderly and safe development of international civil aviation for global peace and prosperity. So my goal today is to recall how good these treaties are for the states and for the civil aviation industry, and what ICAO is doing to help states consider those benefits and undertake the ratification process, and how agencies of the state and the aviation industry can participate. First, I'll just give you the context under which treaties are adopted at ICAO. There are two different paths followed in the lawmaking process. The first path relates to amendments to the Chicago Convention, and this path is governed largely by Article 94 of the Convention. Article 94A reads that any proposed amendment to the Convention must be approved by 2/3 vote of the Assembly and shall come into force in respect of states which have ratified that amendment when ratified by a number of contracting states specified by the Assembly. The number so specified shall be no less than 2/3 of the total number of contracting states. And this is where the problem lies with these amendments in this last sentence of 94A. Although a number greater than 2/3 has never been specified by the organization, but as its membership has increased, this becomes increasingly difficult. So with a membership today of 193 states, any amendment adopted would need 128 ratifications. So that is a steep slope to climb, even in the best of circumstances. The vast majority of amendments to the convention have been thus far institutional in nature, relating to administrative and procedural matters such as membership, budget, permanent seat, and official languages. In substance, the convention has only been amended twice since 1944, which is a testimony to how durable that framework has been. And of course, this will be part of the discussions later tomorrow, how the convention has worked over the last 8 years. But relating to the two principal substantive amendments, the first one being the amendment introduced by Article 3 bis, and it concerns the prohibition of the use of weapons against civil aircraft. It was adopted by the 25th Assembly of ICAO on 10th of May 1984 in the aftermath of the shooting down of Korea Airlines flight KL 007 over Russian airspace on its way from Anchorage in the US to Seoul. The Second Amendment, Article 83 bis, was adopted in 1980, and it concerns the transfer of registry responsibility, set of registry responsibilities on leased and chartered aircraft. This was necessary to ensure there's continuing oversight, safety oversight, where an aircraft operates mostly out of the state of registry for long periods of time, so certain responsibilities are transferred through an agreement to the state of the operator. This is the curve that shows you the process of adoption of a treaty, which starts generally with the inclusion of an item on the work program of the legal committee, as Mr. Gill has just described. And as you've heard, this work program will be reviewed by the legal committee meeting in June. So from inclusion of the item on the work program, the item progresses through study groups or working groups of states, and then this is escalated onto a subcommittee and with the input of a rapporteur, and finally the council. When there's a draft instrument, the council will convene a diplomatic conference. All states can participate in this diplomatic conference. The Legal Bureau, of course, is involved in supporting the process of all these organs. This category of international air law instruments do not require the two-thirds majority that is in place for the amendments to the Chicago Convention. The diplomatic conference determines the minimum number of parties required to achieve ratification, and we have had over the years requirements from as few as 2 parties and to as many as 35 parties ratifying for the instrument to come into force. Since 1947, this is the range of instruments that have been adopted in various fields, including aviation security, aviation safety, air carrier liability, and aircraft financing, which are listed on this slide. And this has been an outstanding achievement of the legal committee, whose 75th anniversary was commemorated in 2022, because the ICAO lawmaking framework has had tremendous success, with some of these treaties achieving almost universal acceptance with 180 parties or more, which is quite rare in international relations. When a state has completed the domestic requirements for the ratification of the treaty, it has to accomplish international requirements by adopting an instrument of ratification with the organization. The domestic requirements, as many of you may be aware, the treaty is considered through the executive, the administration, the cabinet, and in some states, the legislature is also involved. So once that approval is obtained and the ratification is gazetted, there has to be an instrument of ratification, usually signed by the Minister of Foreign Affairs, that has to be deposited with the depositary. And this, for most of the ICAO treaties, ICAO is the depositary of the treaties developed under the auspices of the legal committee. Instruments are deposited by transmitting the originals in hard copy by courier or physically delivering them to the Secretary General in Montreal. No electronic means are permissible at this point. When the instrument is delivered to the Secretary General, of course, this is accompanied by a ceremony with some publicity. Originals can also be sent directly or by courier or through the state's diplomatic missions in Ottawa or Washington, D.C. or New York in the US. In the years 2022 and 2023, ICAO has handled almost 100 depository actions by states. As you already heard, the Assembly has passed a number of resolutions calling on states to ratify various instruments, and consistent with these resolutions on the promotion of ratification, the organization is actively promoting the ratification of 6 key international treaties, which I'm going to be sharing with you today. And these promotional efforts are going on between 2023 and 2024. So on this slide are the 6 treaties I'm referring to. First off, we have the Montreal Convention 1999, which is the convention for the unification of certain rules for international carriage by air. This treaty consolidates the rules relating to the carriage of passengers, baggage, and cargo. And the key benefit is, of course, that you have a modernized compensation regime, and I'll elaborate a bit more about what that involves. And the key takeaway here is that although the treaty has 139 parties, it is essential, because 55 other states haven't yet become party. It is essential that this is universally adopted so that these modernized rules can be uniformly applied wherever in the world a claim arises. The second set of instruments is the Beijing Convention 2010 and the Beijing Protocol 2010, of 2010, one relating to unlawful acts relating to international civil aviation, and the other, the protocol relating to unlawful seizure of aircraft. And these instruments also modernize the legal framework for aviation security by criminalizing acts that constitute new and emerging threats against civil aviation. MP14 has also already been mentioned. MP14 amends the Tokyo Convention of 1963, and it addresses the issue of the rising incidents of unruly and disruptive behavior on board aircraft by improving the ability of states to take jurisdiction over offenses. So in addition to the state of registry, which had sole jurisdiction under the Tokyo Convention, this is expanded to involve the state of landing and the state of the operator. Finally, the 2 protocols increasing the membership of the ANC and the Council, as has been mentioned before. I'll go through these one by one very quickly. I'm not going to teach what these provisions are all about, but just to give you an overview, starting with the Beijing instruments of 2010. As I said, they are modernizing the aviation security regime to deal with new and emerging threats, and they strengthen the capacity of states to prevent and deter the commission of those offenses, and to prosecute and punish those who commit such offenses wherever in the world they may be. These new and emerging threats include acts such as using aircraft as weapons, which became apparent in the aftermath of 9/11 incident, using biological, chemical, and nuclear weapons, or unlawfully transporting them by air is another offense. And also covered under these instruments is cyber attacks of air navigation systems, or seizing or controlling the aircraft by cyber means or other electronic means. So I just wanted to talk about one particular threat that is not commonly discussed as an example to illustrate why this is important. And this is the threat of biological, chemical, and nuclear weapons, or BCN, which is the acronym that ICAO uses, but other UN agencies use the acronym CBRN, chemical, biological, and radiological and nuclear weapons. In a study conducted by ICAO in 2005, it was noted that biological attacks had already been observed in non-aviation environments, such as the sarin gas attack that occurred in the Japanese subway system in 1995, as well as the anthrax incidents which occurred in the United States in the late 2001. It was observed that this kind of threat could be potentially used against civil aviation at any time, but that the existing aviation security instruments did not expressly cover chemical and biological attacks. Hence, appropriate provisions were included in the Beijing instruments. This slide presents some potential scenarios for biological, chemical, and nuclear attacks, such as foodborne bioagents being introduced through in-flight catering, or chemical or biological weapons being mounted on drones and crushed into populated areas. The likelihood of some of these attacks materializing are currently assessed to be low to medium, according to guidance material issued by ICAO, particularly ICAO Doc 10108, which is the Aviation Security Global Risk Context Statement that was last updated in late 2022. However, the fact that they are assessed to be low or medium risks does not mean that they will not happen. And we just have to be prepared to play our part as the legal community when they happen, by having already in place the framework to deal with them. The risk is low, but the 2023 risk profile includes the use of drones and insider threats, which can be effective for deploying BCN weapons. And we just have to reflect and remember, for example, that on the 10th September 2001, an attack using a civil aircraft, although feasible, was not considered to be imminent. Of course, the very next day, everything changed. So if it can happen, it probably will. This is a list of parties to the two treaties I just talked about. And apart from the considerations that I just cited before, it is also important to remember that the threats to civil aviation and the role of ICAO in this regard is recognized also by the UN, which through the UN Security Council Resolution 2309 of 2016 calls upon states to ratify these instruments as part of the global counterterrorism strategy. So, with that brief elaboration, I would say if your state is not on this list, one suggestion I would make in order to help is that when you return home is to inquire why and where your state is in the process, and every little step such as that can help to advance the adoption, and we can all play a part. For MP14, the trend of escalating frequency of unruly passenger incidents was already existing even before the COVID-19 pandemic, which definitely made it worse, and incidents spiked in relation to enforcing compliance with public health measures. As of 10th April 2024, which is around the 10th anniversary of this instrument, we have 47 parties to this protocol, and my colleague Erica will be briefing you tomorrow about the provisions in detail during session 3. Montreal Convention of 1999 has a significant number of parties already. It's ratified by 139 states thus far, but as many as 55 states have not yet ratified, as I just mentioned. And as a result of that, we have a patchwork of liability regimes continuing to exist, with the result that it may cause confusion and complexity in determining which regime covers a particular passenger or cargo itinerary. Before 99 modernization, there were very many different instruments because there was a lack of consensus over 70 years concerning the amounts of compensation, for instance. So one of the important innovations brought by Montreal 99, apart from significantly raising the limit of compensation, was the introduction of the escalator clause, whereby the limits of compensation are reviewed every 5 years to keep them in line with inflation. The last increase took place in 2019, and another review is going on this year through the Legal Bureau and the Air Transport Bureaus at ICAO, because the treaty assigns to ICAO the responsibility to undertake this review. As a result, the issue of setting the liability limits ceased to be a matter of political debate and became a technical one, and therefore avoided the problems that had affected the regimes over the last 70 years. So the limit of liability at the moment for death and injury claims on the basis of strict liability is 128,821 special drawing rights of the IMF, which translates to around $170,000. So these limits will be reviewed and known by the year end, but in the middle of the year, states will be consulted about this through a state letter. This slide is intended to illustrate the impact of an unequal compensation regime depending on the status of ratification of the state and the itinerary of the passenger. So here you see that three passengers seated on the same flight in the same row may actually have a different compensation regime applying to each one of them. Passenger 2, under the Montreal Convention, can be compensated up to $170,000 US. Passenger 1 and 3, on the other hand, have a much lower limit, equivalent under the Warsaw Convention to only $8,300 US, and under the Hague Convention, just $16,000 US. So you can see how this unbalanced situation creates complexity and lack of equality in the handling of compensation claims, and this will only be solved by universal ratification so that we can have a level playing field. So the 55 remaining states can help make this happen. And just to mention that the MC99 also facilitates the use of electronic airway bills, which are an important tool for international trade. Finally, the two protocols amending the Chicago Convention and increasing the membership of the Council and the ANC, in the case of the Council, to ensure better representation of states within the Council, and for the ANC to draw on the expertise of more commissioners. Being elected to the Council, of course, enables the state to be more directly involved in ICAO's work. So once this instrument takes effect, there will be 4 additional seats in the Council to be allocated. As of 5th April, these protocols had been ratified by 93 states, so we have 35 more ratifications to go. And the Council and the organization are particularly pushing for the ratification of these treaties so that they become effective before the next session of the Assembly in 2025, thereby allowing the election of 40 Council members, which is 4 more than the current 36. Resources to promote ratification are available at ICAO to states, and one of these is the ICAO Treaty Collection website, which contains administrative packages which can help you develop your proposal to your administration in the state to support the ratification. It includes a model instrument of ratification as well, and gives a background and summary and benefits of the treaty. This is available on the public website of ICAO on a portal which is under the Legal Bureau. Additionally, ICAO is always ready to provide assistance to states during the process. If you have any questions, you can contact the Legal Affairs and External Relations Bureau at that email contact provided over there. We are happy to answer questions. We are happy to review your draft instrument. Before you submit it, it can be unfortunate if you send an instrument to Montreal already signed by the minister and it contains an error, and then we have to come back and tell you to correct it. I don't know what you would tell your minister in that case. So you're welcome to take advantage of this informal review process. These are some of the activities that have been undertaken by the organization to promote the ratification. Legal seminars such as this one, the International Air Law course. I'll speak about participation at DGCA meetings in due course, and also the Civil Aviation Legal Forum. I'm not sure that Mr. Gill mentioned the next event of the Civil Aviation Legal Advisors Forum will be announced very soon, but I think some of you informally know that it will take place in the United Kingdom this November. There is sometimes some confusion about whether the CAAs are concerned with the matter of ratification, because it involves very many state agencies, Ministry of Justice, Ministry of Foreign Affairs, and the legislature. And I'm here today to tell you, having worked in the CAA before, that the CAA play a very crucial process as far as aviation treaties are concerned. They can be the champion in the state to drive the process, to advise the government and make proposals through the apparent ministry, and to coordinate with the agencies I just mentioned, undertake consultations with stakeholders, and also to coordinate with ICAO for any assistance or clarification. We tried a different approach as well, to go to high-level meetings, meet with DGCAs or ministers, and present to them the information that I'm sharing with you today. And during 2023, we went to 5 different regions and made presentations at that level, so that resources and time could be allocated by the states towards the work of processing ratification of pending air law instruments. One of the items that was adopted by these meetings was the tracking matrix for treaty ratification. The matrix is a tool which enables the state and ourselves to understand what the progress is towards ratification. This information helps the organization also identify whether there are any particular needs that the states have to complete the process, by identifying when the ratification process has reached certain key milestones. And of course, it also allows states that are not considering ratification at all to say so that resources can be efficiently allocated. Once the tracking matrix is received, we collate and aggregate the data. By the way, just to mention that this tracking matrix has been sent out to all states by your various regional directors to be filled in by the CAAs. So this data is aggregated, and this is just to illustrate how this tool can work. On this slide, one state, for example, indicated that they were not considering the ratification of the Beijing Convention and Protocol because they already had domestic legislation that covered those new offenses. Of course, in that case, that state, and like many other states that may have already modernized their national legislation, we would be happy to provide clarification. And in that particular case, we would be saying that it's not enough to have the best domestic legislation. The way these treaties work is that you need to become a party together with other states around the world because it's important for the provisions to have global reach, because as you know, many of these offenses may be committed in one part of the world, they may have an impact in another part of the world and victims in another part of the world. So you have to be party to a global treaty framework with other states in order to ensure that the crime is punished wherever in the world it originates or is executed or the offender is found. We've also held several events around the world, such as workshops and seminars to promote ratification in West Africa last year, as well as in Singapore and also in Europe. And states in other regions are also welcome to invite ICAO to arrange such an event for them in their regions. Last but not least, we have the international air course, which was launched in 2017 and is delivered in 7 modules over 5 days. It's an excellent introduction to aspects of international air law, especially for people who are just joining the industry. There's a high turnover of people, and this course is good not just for lawyers but also for non-lawyers, and provides the competencies for them to support their organizations in the implementation of air law. So in conclusion, I just wanted to say that we are all in this together, and the only question we would ask ourselves is, what can we do next to advance ratification in your states and around the world? So over to you, and thank you for listening to me.
Yes, thank you very much, Legal Officer Andrew Oplot, for the presentation. We have learned through the treaty-making process, as well as the international air law treaties, as well as actions for us to ponder upon the ratification. And now we would like to move on to the discussion where we'll be accepting some questions from the floor. We had some excellent presentations prepared by 2 gentlemen here on the stage. So if you have any questions regarding these 2 presentations, please raise your hand and we will deliver the mic to you. Is there any questions? Yes, I see a gentleman raising his hand at the corner wearing an eyeglass. So please deliver the mic to him. Yes. Before you address your question, please introduce yourself first.
안녕하세요. 저는 정종찬이라고 합니다.
Hello, I am Jung Jong-chan.
Question, let us have our gentlemen wear their interpretation device so that you'll be able to understand the questions. 네, 잠시 동시 통역기를 사용하신 뒤에 질문을
Please give a few moments to wear an earphone for simultaneous interpretation.
for English. And I guess we're set. 네, 이제 질문해 주시면 될 것 같습니다.
Please go ahead. So, well, I want to ask a question about the fundamental question about the functions of ICAO. Under the international aviation law, so there is a definition about the aircraft. But if you see the Article 2-1, there is an exception articles about the aircraft. They says that if there is any, there is a definition that which excludes the scope of an aircraft, which cause reaction against the air, and then also about the air reaction against the surface and water space is excluded from the scope of the aircraft. So does it mean that the water space related reaction is defined under the IMO framework? So if we combine the land surface and water surface, well, they are considered identically. So when they are considered identically, that means that we may have the aircraft that flies over the land surface. So when it comes to wing aircraft, winging ground aircraft under the IMO, I was wondering if you are prepared to have the convention to support both of them, like winging aircraft.
To have some compact with regarding the flying vehicles or the UAM. Is there any gentleman who can address this question? Yes.
Yep, thank you. The question, of course, touches on definition of aircraft. And one of the remarkable things about the Chicago Convention is that although the word aircraft is used over 100 times, it is not defined. And that is probably with good reason and shows the remarkable foresight of the framers of the convention not to have defined this term, which could have been related to the state of technology at that time. So the fact that it was not defined has enabled the evolution of the definition to align to existing technology. So the definition that the gentleman who asked the question was referring to is found in an annex to the convention rather than the convention itself. And so if there are any potential issues that need to be taken care of regarding that definition, it can be achieved through an appropriate amendment to Annex to Annex 6 of the convention, Annex 7, yeah, to Annex 7 of the convention, and that is the forum at which such a matter could be taken care of, presented by the state, and it would be processed through the Air Navigation Bureau and the ANC. So the good news is that there is an avenue to do it much simpler than tackling an amendment to the convention itself. Thank you.
Yes, then let's move on to the next question. Is there anyone who has a question? Please do raise your hand and we will deliver the mic to you. We have also talked about the treaty-making process as well as some strategic opportunities that can be found at ICAO. So regarding all the things that has been shared throughout the two presentations, if there's any questions, please raise your hand and let us know. Maybe because this discussion ends and there's lunch, is maybe the people are going to take that opportunity to ask the question themselves personally. Is that so? I can see some nods. Well, if that's the case, why don't we call this day off and give the two gentlemen a big round of applause for their wonderful presentation. Thank you very much. Yes, thank you very much, Mr. Michael Gill and Mr. Andrew Opolot for joining us. You may now go back to your seats. Yes, this is the end for our morning session here at Day 1 at 2024 ICAO Legal Seminar. Well, now we're going to move on for lunch, which is thankfully prepared by Incheon Airport. Well, Incheon Airport, thank you very much for hosting today's lunch once again. Well, as it opened its doors in 2001 with the goal of serving as a global hub for Northeast Asia, we have received support from the public, government vision, and policies becoming the key airport connecting global airlines. We extend our sincere thanks once again to the Incheon International Airport for preparing today's luncheon, and we seek to see you all once again at 1 o'clock for the session number 2. And for the time being, as the lunch will be served at your table, those with the special dieties, I am sure that you have received your special dietary coupon with you at the registration desk. So please place them on the table so that you will be able to receive the rightful diet fixed to you. So with your meal, please help yourselves, and we will see you all at 1 o'clock. Thank you very much. Well, all right, everyone. I guess we're now ready to begin our afternoon with the session number 2 entitled Aviation Safety and Security. This session will be moderated by Mr. Jae-yoon Lee, the Associate Professor from the Chinese University of Hong Kong. Let's first welcome the moderator to the stage with a big round of applause. And I'll continue to introduce our 4 esteemed speakers to you. First of all, we'll be joined by Mr. Venua Berhagen, the Senior External Relations and Legal Officer at the Legal Affairs and External Relations Bureau at ICAO. Welcome. And moving on, we will invite to the stage Mr. Kang Won-bae, the Director of Aviation Investigation at Korean Air. We're pleased to have you, sir. Please join us on the stage. And now, let me introduce Mr. Denise Kim-dong, the Deputy Director of Monitoring and Oversight at the Air Navigation Bureau of ICAO. Welcome. And now, as for the last but not the least, let's welcome Mr. David Willa, the representative in Singapore of European Union Aviation Safety Agency. Let's welcome him with a big round of applause. And now, I would like to pass the microphone over to our moderator, Mr. Jae-yoon Lee. Sir, please.
Thank you. Good afternoon, everyone. Also, good morning or good evening for following this by YouTube. So, it's my pleasure to moderate ICAO legal seminar. I'd like to thank the Ministry and Land and Infrastructure and ICAO and Transport and ICAO for your kind invitation. Before we start this important session, I would like to say a few words. One source of great pride in my life is the fact that I have attended all of the ICAO legal seminar in Seoul in 2006, 2009, 2012, 2015, 2018, 2022, and 2024. I have found 2 photos that were taken at the 2012 ICAO legal seminar, exactly 12 years ago. Can you please put that photo on the screen? So I can see many familiar faces who are attending here as well. Can you raise your hand if you can see your younger face? Yes, great. So can I invite the audience to give them a round of applause for their consistent support to this seminar? Thank you. The other photo, next one please, I want to share with you is this one. You can see ICAO LAB Director Michael Gill and me speaking in a session. Michael, what happened to us? All right, now I'm back to my main role. Please close it. Okay, so I'm going to moderate session 2, the Aviation Safety and Security. It is a relatively long session with 4 speakers. So we have decided to have 2 mini sessions with a short break in between. It's mainly because we have a number of guests from Montreal, and there is a 13-hour time difference between Montreal and Hong Kong. So, sorry, I am Korean, but I work in Hong Kong, so I keep making a mistake. Sorry about that. So for the next 65 minutes, we're going to have 2 speakers, Mr. Benoit Verhagen and Captain Bae Kang-won will make their presentation, followed by Q&A session. That will have a 10-minute break. After the short break, Captain Denis Goidong and Mr. David Waller will make a presentation for about 40 minutes, followed by another Q&A session. So Benoit is our first speaker. Let me briefly introduce Benoit. Detailed of CCV is on our website. Benoit is Senior External Relations and Legal Officer in ICAO LEB. He joined ICAO in 1993. His work at ICAO LEB includes legal aspect of international air navigation, LEB representative in the ICAO Air Navigation Commission, and ICAO Safety Oversight Auditor. His topic today is global legal framework serving aviation safety over 80 years. Please welcome Benoit Verhegan.
Excellencies, Secretary General, dear colleagues and participants, good afternoon to all. It's really a pleasure to be here. For my part, this is the second time I attend the legal seminar. I was here in 2018, and it's always a pleasure to be in Korea. And I would like, of course, first to thank very much Molit for the wonderful organization of this seminar, and the Incheon Airport Company for the lunch, the excellent lunch we just had. Thank you, Professor Lee, for your nice introduction. What I would like to do today is to take you along on an international flight and cover the essentials that will make a trip safe in terms of responsibilities. Through a very simple question: who is responsible for which applicable laws and regulations and where? So we'll go through this outline with you, starting with the Chicago Convention that confirmed the sovereignty principle, look at the limitations to this principle for the sake of safety. We'll address the different technical publications of ICAO and their legal status, which will lead us to the air navigation plan and the amendment process of the regional plans. And finally, we'll look at the certification licensing of the users, mainly the aircraft, the crew, and the operators. Finally, we'll reach some conclusions in terms of responsibilities. The Convention of 7744 is the result of a general agreement on the basic principle and institutional solutions for civil aviation worldwide after the Second World War. But at the same time, it is the result of a major disagreement on the issue of traffic rights, as the principle of sovereignty remained and prevailed. Indeed, Article 1 of the Convention declares that each state has complete and exclusive sovereignty over the airspace above its territory, while Article 2 states that the territory of a state consists of its land areas and territorial waters. Article 12 refers to the high seas. This means, very simply, that all waters beyond territorial waters are high seas, and the airspace above its international airspace from an aviation viewpoint. The UN Convention on the Law of the Sea, UNCLOS, of 1982 confirmed that territorial waters extend up to 12 nautical miles and that there is freedom of overflight beyond. That means that above the high seas, and including the exclusive economic zone, that extend up to 200 nautical miles. This was studied carefully by the Legal Committee of ICAO, which concluded in 1994 that as such, the Law of the Sea Convention was fully compatible with the Chicago Convention. So I have found on the internet this sketch that is illustrating very well this concept. While you may have under the Law of the Sea Convention several zones for maritime purposes, it remains that for the airspace, there are only two zones that are the national airspace, the sovereign airspace, up to 12 nautical miles, and after which we have entirely international airspace having the status of high seas. There are not so many exceptions to sovereignty in the Chicago where air transport as such is concerned, save a regime allowing overflights and technical stops for non-scheduled flights. Apart from that, virtually all international flights have to be carried out through authorization. Article 11 of the Convention, a fundamental provision, reinforced this principle of sovereignty, saying that the laws and the regulations of the state concerned apply on its territory to all aircraft, subject to non-discrimination. However, this sovereignty principle is further subject to the provisions of the Convention. Indeed, the right of state parties to the Convention to regulate air navigation over their territory is not absolute, as specific limitations concern principally safety. So Chicago may not have been a great success from an economic viewpoint, but it was a real achievement from a technical and safety viewpoint. This is expressly reflected in several provisions of the Convention that you see on the screen, in particular the preamble and Article 44. To this end, limitations on sovereignty include the commitment of states to comply with what is called international regulations. You can find several examples in the Convention. I will refer to two at this stage. Article 12 on rules of the air stipulates that each state undertakes to maintain its own regulation in this field uniform with those established under the Convention. And Article 28 refers to the obligation of states to provide air navigation services in accordance with the standards and recommended practices established under the Convention. Such international standards and recommended practices that we call SAPs are adopted by the ICAO Council and placed in the annexes to the Convention. We have currently 19 annexes, but it's not exhaustive. So we have this paramount provision in the Convention, Article 37, by which the contracting states undertake to work together to ensure the highest possible degree of uniformity in their regulations in complying with these SAPs. So it's time now to go through so you have here the definitions that can be found in the Assembly resolution and in the forward of annexes for international standard and recommended practices. I take the opportunity, since we referred this morning to Annex 9, that there is an exception. So if you are not aware, you will see that these definitions are the same throughout all ICAO annexes, but not for Annex 9. Annex 9 is a different definition for a standard because it was by essence a less technical annex. So the Chicago Convention itself is an instrument of public international law. That means a treaty that governs the rights and obligations of states and that is fully binding on them. For the annexes, it's different. The annexes, however, do not have the same legal status as the Convention. If full compliance with the standard proves impossible, immediate notification of a difference may be made by virtue of Article 38 of the Convention to ICAO, and ICAO will publish it. So it can be said that ICAO standards are legally binding to the extent that the state concerned has not notified a difference. And as was said by a chairman of the legal committee a few years back, if no difference is notified from a standard, it has the status of rule of law and it is fully binding on the state concerned. Recommended practice, though, in the annexes do not have the same binding force as standards, since they are not covered by Article 38. They have a lesser legal force, but like standards, they must be adopted by the Council at a 2/3 majority vote. And furthermore, the Assembly, even if recommended practices are not covered by Article 38, the Assembly nevertheless requires states to also notify ICAO of differences from recommended practices. So if you look at the forward of annexes, you will see the description of the different components of an annex. And among the SAPs adopted by Council, not only you have the paragraphs concerned, but it also includes appendices, definitions, tables, and figures. Apart from that, annex also contain guidance documents that are approved by the Council at the simple majority voting, not adopted, which are the notes in the attachments, for example. Other documents approved at simple majority by the Council include the technical instructions for the safe transport of dangerous goods by air, the PANS and the SUPs. The PANS are the procedures for air navigation services. They are not SAPs, they are not placed in annexes, but they are approved by the Council for worldwide application. They are too detailed to be subject to the procedure of Article 90. It would be too cumbersome. But the Assembly, nevertheless, wished that SAPs and PANS be both developed by the Air Navigation Commission through a very important and extensive consultation process that is applied to both types of rules. Besides the PANS, we have the SUPs, the supplementary regional procedures. They have a similar statute to the PANS in that they are approved by the Council, they are not SAPs, and they are applied only within the respective ICAO air navigation regions concerned. And then you have circulars, manuals approved by the Secretary General that contain guidance that complement SAPs and PANS. So this is a short description of the cycle for the amendment of SAPs. It takes on average 2 years. If you are not aware, there is a very interesting description of these different technical publications of ICAO that used to be found at the back cover of the annexes, and now you can find them at the back cover of the manuals, where you will have that list. We just went through it. The SAPs, the PANS, the SUPs, the manuals, and it also refers to the air navigation plans. The air navigation plans are also approved by the Council. They detail the requirements for facilities and services for international air navigation in the different ICAO air navigation regions. The ANPs, they form the bridge between the global ICAO provisions, meaning the SAPs and the PANS, on the one hand, and the national plans of states and their implementation on the other, given the obligation of the states under Article 28 to provide such air navigation services for international traffic. And the link between the two are the SUPs. The SUPs actually form the procedural part of the air navigation plans. In this context, Annex 11 refers about air traffic services, refers to flight information regions, the FIRs, which delimit the area for which a state is responsible for providing air traffic services, or ATS. Such FIRs may therefore include sovereign airspace, but also high seas airspace. So the NPs are therefore divided into FIRs, each of them being managed by a competent ATS authority designated by the state responsible for ATS in the airspace concerned. So here you have a general map on the different ICAO region and the division of each region into FIRs. So this is the map of the region here. You see in the center Republic of Korea, the FIR Incheon, and the surrounding FIRs. The Assembly, through Resolution A4110, Appendix G, that is entitled the Delimitation of Air Traffic Services Airspace, establishes the 7 cardinal principles that govern ICAO air navigation planning. I will highlight a few of them. The first one, the limits of ATS airspaces, under sovereignty or not, shall be established exclusively on the basis of technical and operational considerations for the sake of safety, efficiency, and economy. Second principle, ATS airspaces should not be segmented or fragmented for other reasons. You will see at the number 6, the delegation of responsibility by a state to another for providing air traffic services over its territory is done without any derogation of sovereignty. And last, the Council approval for the provision by a state of ATS over the high seas does not imply any recognition of sovereignty of that state over the international airspace. So you will see that the Assembly wished to remain as remote as possible from sovereignty issues, and accordingly, you will note that the FIRs are usually named after cities, but not after states, exactly to stay away from connotation of sovereignty when dealing with air navigation planning. Let's go through the amendment process of the plans. The NPs are a compendium of the responsibilities assigned to states for the provision of air navigation facilities and services in a given area, pursuant to Article 28 and in accordance with regional air navigation agreements. The aim of ANPs, approved by the Council, is to ensure that the facilities and services provided by a state keep forming an integrated system with those of other states, which may necessitate sometimes an update and amendments. Such potential amendments are first considered by the ICAO regional planning and implementation groups. You certainly heard about the PERGs. Thereafter, the amendments or the proposal for amendments to NPs are usually undertaken by correspondence between ICAO and member states as coordinated by the ICAO regional office concerned. And I've seen this morning that Mr. Taoma, the regional director at the Bangkok Regional Office for Asia Pacific, was here and is therefore the person responsible for this region to coordinate any amendment to the Asia Pacific Air Navigation Plan. There is a formal ANP amendment procedure that has been approved by the Council in 2014. It stipulates that a state or a group of states in a region may make a proposal to the Secretary General to be submitted through the pertinent regional office. It must be duly documented, including all the facts leading to the conclusion that an amendment is necessary, and the proposal is then circulated, analyzed by the Secretariat. In the event of a consensus, the President of the Council will give its approval to the amendment. However, should there be an objection, if no consensus can be reached while the proposal is maintained by the proposers, it will be sent to the Air Navigation Commission, which will present a technical report to the Council. And on the basis of that technical report, the Council will make its decision on the allocation of responsibility for the provision of ATS services in the area concerned. As regards the high seas, the cardinal principle of the Assembly is echoed in Annex 11 at paragraph 212. Those portions of the airspace over the high seas or airspace of undetermined sovereignty, which by the way refers to Antarctica, where air traffic services will be provided, shall be determined only on the basis of the regional air navigation agreements. Of course, because Article 28 deals only with sovereign airspace and the obligation of states for their territory. That means what? That means that it's quite unique. The ICAO Council has an exclusive jurisdiction to make these decisions over the international airspace. It is the only legal entity that has such ultimate authority for air traffic over the high seas. With respect to national airspace, the state will nevertheless keep its ultimate sovereignty. In this regard, paragraph 211 of Annex 11 echoes another assembly principle. By agreement, a state may delegate to another the provision of air traffic services. And of course, a note under this provision refers to the possible withdrawal of such delegation, but in good order, it is expected that it will be made through due consultation to have a smooth transition. We had in 2015 an example illustrating such principles. The national airspace of two states used to be within the FIR managed by the ATS authority of a third neighboring state. However, the two states wished to withdraw their delegation of authority for the ATS and establish their own FIRs. But discussion showed that it was not pertinent to establish FIRs just for these two states. And they did not pursue the amendment process to establish the said FIRs. But nevertheless, they didn't want to stay in the FIR of the third state, and they wished to keep the territorial airspace outside of the initial FIR. There is therefore a sectorization of the airspace within the FIR. So it's like two little islands within a big FIR, airspace of which is not governed by the ATS authority in charge of that at FIR. The states concerned wish to keep their own sovereign authority over their exclusive sovereign airspace. So this shows that not every airspace would necessarily be actually covered by an FIR. And by the way, the audio around, we also have a case where west of Ecuador, we have a portion of high seas that has not been assigned to any authority. And therefore, we have unassigned airspace over the high seas at that place. But to continue with the example I just gave about these two states. So they wish to be their own master for their own territory. Fair enough, they are sovereign. And they initially considered extending their sovereign airspace up to the end of the exclusive economic zone of 200 nautical miles. We had very serious discussions with the state, and finally they had to acknowledge that airspace beyond the territorial waters of 12 nautical miles are indeed international, without any sovereignty, and that airspace over the high seas in the initial FIR remained untouched as approved by the ICAO Assembly. We had in 2021 another example that offered an interesting development. A state wished to withdraw its delegation of responsibility for ATS to a neighboring state and proposed an ENP amendment to establish its own FIR. As there was an objection, the ANC was seized, the Navigation Commission of ICAO was seized of the matter. Eventually, it became clear that there was a lack of certainty on the required contents of the technical report to be submitted by the ANC to the Council. And the Council procedure was silent about it, actually. It referred to the report, but not saying what should be its contents. Therefore, the ANC established a group supported by the Secretariat, which in 2023 developed a procedure through checklist to ensure that future reports of the ANC fully meet the requirements of the Assembly in Appendix G of Resolution A4110, to ensure that the reports fully address and duly address only technical operational issues for safety, efficiency, and economy reasons. So now that we have a geographical idea of who is responsible for what in the airspaces, let's look at the users of the airspace, namely the aircraft, the crew, and the operators. The concept of aircraft registration implies the responsibility of the state of registry for the safe operation of aircraft. In particular, the state of registry is responsible for the radio licenses, the airworthiness of the aircraft, and the crew licenses. So the state of registry will issue the certificate of airworthiness and the crew licenses. For the operations, the international aircraft operations are governed by annexes to the convention, which refers to the state of the operator as being the state where the operator has its principal place of business or residence. And in case of commercial operations, the state of the operator has to issue an air operator certificate, an AOC, and operating specifications to certify an airline's ability to operate its aircraft safely during international operations. Now, we spoke about the standards and the possibility of filing a difference. So if the conditions of issuance of a certificate of airworthiness or pilot licenses do not fully comply with the standards in Annex 1 and 8, the state of registry has to comply with 3 obligations. First, notify the difference to ICAO. Second, endorse the license or the certificate, meaning making an annotation on the documents about the difference concerned. And third, the operator has to ensure that the crew and the aircraft concerned would seek overflight authorization from other states because the requirements of the annex will not be met. While over the territory, like over the high seas, the state of registry and the state of the operator, they keep their own authority, it's important to note that the differences are not exportable. For an aircraft pilots, operators must comply with the local aviation regulations. That is what is said in Article 11 and 12 of the conventions. The state having sovereignty establishes and applies its own laws and regulations. I think that's the wrong button, sorry. Annex 6 further stipulates that before flying, pilots must be familiar with the laws and regulations in force in the areas they have to traverse. And it is true that for an airspace, the standards could be complied with or be deferred to, but they can be deferred to by less stringent or more stringent. To note that the standard is the average situation. If a state decides to have much more stringent requirements, that becomes a difference. For example, if in the state concerned, the pilot can never be more than 50 years old, it will be a difference from the standard that say can be up to 60 years old. So that would be a difference. To ensure smooth international navigation while preserving safety, there is, however, a magic provision that is Article 33. Article 33 to me is really a splendid creation of the Chicago Convention. It provides that states are obliged to mutually recognize the validity of foreign airworthiness certificates and crew licenses when they fully meet the minimum standards in Annex 1 and 8, even if their own national legislation would provide for more stringent requirements. I gave the example of the pilot. Even if the law says in the state pilots cannot be more than 50, if the foreign aircraft coming with a pilot that is complying in his license with Annex 1 and is 60 as per the ICAO standard, and the state that has a legislation about 50 years old maximum is obliged to let the aircraft come in and cannot prevent the pilot from flying. And we have exactly the same mechanism. When we were asked about the air operator certificate, the Air Navigation Bureau, our colleagues, they came to us saying there was an issue about the mutual recognition of AOC. And of course, the Chicago Convention at the time of its drafters could not anticipate the concept of state of the operator and AOC. Therefore, what we did is that we just translated the same terminology as Article 33 within the standard that is now placed in Annex 6. So if a state has not filed a difference to that standard, the state is obliged, like the mechanism of Article 33, to recognize the validity for an AOC and operation specifications that are complying with the requirements of Annex 6, even if the national legislation is more stringent. So coming to the conclusions, I'd like to have a rapid overview of the responsibilities of the key players in respect of international air navigation. First, of course, the state having sovereignty. We went through Article 11, the limitations for the sake of safety, and I just spoke about the recognition of AOC and of the certificate of award, in a sense on how would a state verify that. For verification purposes, there are several means. First, we have Article 16 of the Convention that provides the states have the right to search aircraft to inspect any documents to be on board. As a source of information, the state and the inspectors also have the published differences that can be found on the ICAO EFOD system, accessible to all states. Third source, you have the aeronautical information publications. And in this regard, the Assembly and Annex 15 stipulate that states shall publish their differences from SAPs and PANs in their AIP, those that are significant for safety. A fourth source of information is the ICAO auditing report, including the publication of any significant safety concerns. You also have Council resolutions or Assembly resolutions, like the Assembly in 2022 adopted two resolutions condemning the Russian Federation for infractions of the Convention and the Democratic People Republic of Korea for the launching of unannounced missile launches. What is important to note is that the Assembly realized, the community realized during its 36th session that states were very keen on observing safety oversight-related obligations, but they were, let's say, less observant of their obligation under Article 11 and 12 to effect surveillance on foreign aircraft. So that is a reminder that was placed in Resolution 36.6 that is quite important and that addresses this matter in quite details if you're interested. Another key player is the state, of course, that provides air traffic services. They are provided over a sovereign territory by virtue of the national laws and regulations. We have seen that in accordance with Article 28. And by the way, if there is delegation of authority to provide air traffic services on another state, the laws of that other state will apply over its territory. So the laws that are applicable are always those of the territory concerned, even if there was delegation of authority for the provision of ATS services. Which are they? The applicable laws and regulations stem from Annex 2 and Annex 11, but the implementation differs over the high seas. For Annex 2, it's very clear. The Council said the standards of Annex 2 are rules of the air. They fully apply over the high seas, no differences. It's different for Annex 11. The Council said in Annex 11 that state providing ATS can implement Annex 11 in the same way throughout the FIR, be it over the in the sovereign airspace or the international airspace. But over international airspace, the fundamental principle remains. A state has always to ensure there is freedom of overflight. I will finish here with the state that establish air defense identification zones. There are a few in this region. Just to mention that it's not common. We maybe have like 20 of these ADs in the world. But what is very important to remember is that the procedures in accordance with guidance offered by ICAO must be limited to providing a flight plan, and especially the procedures should not be inconsistent with the ATS procedures of the airspace concerned. It is not said clearly like that, but even if it's not legally forbidden, it is safety-wise much better to avoid establishing an ADIS that would extend over the FIR of another state. And that you will see more details in this manual on civil-military cooperation. Now, the ICAO is a player. You have, of course, the Assembly. What I'd like to say about the Assembly is that we always say the Assembly resolutions are not binding on states. They are of persuasive moral value, for the most. But I'd like to insist on one thing. Assembly resolutions are binding on the ICAO organs. They are binding on the Secretariat, the Secretary General, the Council, the Air Navigation Commission, which means what? When there is, for example, a proposal for amending an air navigation plan, states will make their proposals. At the end, the Air Navigation Commission, in its technical report, and the Council in its decision, would be obliged to fully abide by the terms of Assembly Resolution 4110, Appendix G. So they will be obliged to consider only the technical safety operational aspects for economy reasons. So no politics, in principle. The President, I'd like also insist on one thing. The President, when there are no objections, he approves the ANPs, but he has a very important role when there is a problem that could be meteorological events, there could be conflicts with, use of ammunition, of all kinds of arms, that would require a deviation, a temporary deviation of the air navigation plans. So Annex 11, if you're interested, is paragraph 232, allows the President to approve contingency plans as temporary deviations from the NP until services are re-established, and this is made through consultation. For example, when we had the Libyan war, we were unable to be in contact with Tripoli FIR for the provision of air traffic information over the Tripoli FIR. So we couldn't get hold of the ATS authority. So we asked Malta, through a decision of the President of the Council, to provide such services on behalf of Tripoli FIR during the events. And last, of course, the Secretariat were here to support the ICAO organs and to provide guidance to states, to train, and to be, of course, at the service of all of member states. We are civil servants who are here to serve our community. At the end, I'd like just, it's personal selection, but a few milestones. We celebrate the 80th anniversary of the Chicago Convention. I picked a few key dates as far as I'm concerned. So in 1948, the Council decided the rules of the air are those in Annex 2. Michael Gill spoke about the amendments, the fundamental amendments to the Convention, Article 82 bis and 3 bis. Believe it or not, the AOC was invented only in 1990, even if the concept of state of the operator was already there when Article 82 bis, of course, was adopted in 1980. But we had to wait another 10 years to have the concept of AOC being placed in Annex 6. 3211 is the Assembly resolution that established the Safety Oversight Program. Very important, and I'd like to have a little word from my colleague Armando Quiros that deceased last week. I was very privileged to work with him. We drafted together Assembly Resolution 3211. So I have very fond memories of our work. At the time, we realized it was a very important step in ICAO's life. What is interesting is that sovereignty, you remember we spoke about the principle of sovereignty. We could not just arrive in a state and audit a state. We had to respect its sovereignty. So what we did is that we placed in the Assembly resolution a requirement for the audit to take place under the signature of a memorandum of understanding, by which the state would relinquish part of its sovereignty and allow ICAO to make audits and eventually to publish the results. 2001, to me also a key date. It was not easy because the French in particular were not very happy. They were, of course, and we all sympathize with that, in favor of multilingualism. But we realized during the audits that this was essential for the inspectors to be able to have a common language in order to validly review licenses and certificates on board, meaning that all principal safety documents on board, if not issued in English, should have a translation into English. And that improved a lot the way inspectors could abide by their duties. 2001, of course, there was the 9/11.
Sorry, Benoit.
Yes, I finished. 1 minute left? Okay. So the 9/11, it was important, is where the Assembly said, okay, you have to effect consultation to prepare amendments to SAPs and PANs, but not if there is a real urgency. And the urgency was applied for the cockpit doors for an amendment to Annex 17. Annex 19 in 2013 was the creation of this annex devoted only to safety management. And I will finish with 2017, just to speak for my own shop and for the Secretariat. The manual on the implementation of Article 83 bis, it was a joint effort of Air Navigation Bureau and Legal Bureau. I think it was the first ever we had this kind of joint efforts. And even if it speaks about Article 83 bis, go through it, it reviews a lot of safety-related aspects of the Convention. It's Article 30, Article 31, Article 32, and so on. So I wish to thank you very much for your attention. And I wish again to say thank you so much to Modit for organizing this seminar. Thank you.
Thank you, Benoit, for your comprehensive presentation. Also, thank you for your on-time performance. It was not easy to cover so many different and important aspects of aviation safety within those short period of time. Thank you. So our next speaker, before we have a break, so as a moderator, I'll be very strict on coffee break. So I'll make sure we have a coffee break, 2:10. But before we have a coffee break, we are going to have our second speaker, Captain Bae Kang-won. Captain Bae is a director of the aviation investigation team in Korean Air. In Korean Air, he has held various leadership roles, including director of corporate safety and security investigation, flight operation quality teams. His topic today is common issues in aviation safety and security in implementation of legal framework. Captain Bae, the floor is yours.
Time-wise, it's a very critical time. It's coming to the 2 o'clock, and as our moderator, Professor Lee said, our body also needs some of the waking-up call for the coffee. So I'd like to make a pace a little bit faster. So if you think it's too fast, give me some tips, then I can slow down maybe a little bit, okay? Your Excellencies and all the distinguished guests and ladies and gentlemen, good to see you all. My name is Kang-won Bae, as introduced, and I'm a Korean Air Airbus 330 captain, and I'm also working as a director of the corporate safety. And it's a great pleasure to participate and honor to be invited as speaker and for such an important ICAO seminar. As you can see, this is me. And today, I'm going to talk about the common issues on aviation safety and security implication and legal framework. And in preparation, I've had many valuable opportunity to meet up those safety and security experts and legal professionals. And aviation safety, as you know, and security is interdependent, it's connected concepts. By understanding and nurturing this relationship, we can create a safer and more secure sky for everyone. And today's focus is on aviation safety and security with a particular emphasis on how serious injury. You may have heard it a lot. Serious injury are defined in aviation accident investigation. And whilst there are fatal cases of the accidents, it's very easy to and then very straightforward to address. But on the other hand, some of the cases in serious injury can present some ambiguity during investigation. Sorry, it's moving on. And the clear definition of the serious injury is crucial for the objectively assessing the accident severity and determining liability, and fostering international cooperation on safety standards. This will be key focus on my presentation. And please take a look at the picture on the screen here. And isn't it familiar scene nowadays? You may see this kind of picture or on TV news and the media. And nowadays, very often than not, we see this turbulence-related news. And it's even get some of the fear of flying. Myself, I'm a captain, but when I have this kind of news, I always have some fear. One of the ongoing challenges in aviation safety is managing the risk of in-flight turbulence and the potential injury it can cause. And especially the cabin crew. As you can see on the left side of the corner, the ladies, that's cabin crew of the flight. And these people are particularly face a very difficult situation during turbulence. While a safety protocol requires them to be secure themselves and be seated, but they have other duty to protect, and they are responsible to protect their passenger at the same time in the such events. Balancing these kind of priorities is very crucial, especially since cabin crews are often at the risk of injury in turbulence conditions. And I want to show you the data released by the Flight Safe Foundation, year 2023 safety report just released last month. And it suggested that in-flight injury are the most frequent type of aviation accident recent year, particularly over the past 5 years. And the table included in the report, as you can see, indeed, the turbulence is the leading cause of in-flight injury of aviation accident, followed by the runway excursion. And interestingly, recent studies by meteorology expert suggested that the possible connection with the global weather pattern changes and with increase of this kind of injuries. And coming to the main topic here, the serious definition in the ICAO and Act 13 is crucial for classifying aviation events. This international standard provides a framework for the investigating accidents and incidents to identify their cause and prevent further future occurrences. And clear interpretation of the benefit, airlines and authority and all stakeholders. And ICAO Act 13 is first adopted in 1951 and has undergone 12 amendments to reflect the revolving environmental considerations and technological advancements and the reality of the daily operations. However, one area where further discussion may be beneficial is the definition of serious injury. While this definition was amended directly to that provision directly in 1988, in Amendment 7, the pace of the technological change and evolving societal value may warrant further exploration. And as you can see on the screen, this is the definition of the serious injury in the Annex 13. I do not want to go to read all the detail, but I believe there's some consideration in the industry for the potential for improvement. The current definition of the serious injury might benefit from the improvement to ensure objective assessment, facilitate international comparison, and enhance safety data analysis. This could involve exploring medical expertise for evaluating and standardizing the definition across the country. By fostering this discussion, the international aviation community can work towards continuously strengthening the effectiveness of ICAO Annex 13 for the benefit of aviation worldwide. Sorry. And it is also very interesting to consider how other transportation sector approach the definition of the serious injury. For example, as you can see on the screen here, is that the European Commission has established a detailed definition that incorporates scientific and medical consideration. This level of detail reflects the importance of a clear and objective definition in a field where legal implications and responsibility can be significant. And this is the US Department of Transportation standard of serious injury with an in-depth research result. And they are fostering and try to embrace more medical expertise, and extensive study have been applied to their formula. They using a formula of definition of serious injury. And interestingly, this is a Chinese letter language, and this is the Chinese criminal law reference of definition of serious injury with a very detailed and thorough full document to apply their transportation-related injury. And while this definition may not directly apply to the civil aviation safety investigation, it offers valuable insight into the legal considerations surrounding injury classification. And I just added some of the English version of this document for your reference. Later on, you take a look at the material, my presentation material. And it's interesting to see how other transportation sector and legal system approach the definition of serious injury. And many incorporate the scientific, as I said, medical consideration, resulting in a detailed and evolving definition. And this ongoing process of refinement ensures that these definitions remain relevant and effective. While ICAO 13 provides the valuable framework for aviation safety investigation, perhaps exploring similar approaches to defining serious injury as other transportation does could be beneficial. And by fostering discussion and incorporating more objective criteria and potentially considering periodic review. This is another important word, potentially periodic review. We can work towards a definition that better reflects the current medical understanding and serves the best interest of the aviation safety. And now let me tell you some of the different aspects. Principle of legal interpretation. principle of legal interpretation. I'm not intending to bring you back to the law school freshman classroom, but the law contains certain corresponding facts and the ideology of the social life in it, which are expressed in the words of the provisions. Therefore, the interpretation of the law begins with a literal and logical interpretation of the linguistic meaning of the provision, but requires a purposeful consideration. A competent interpretation is an interpretation based on the authority given to the state agency. Judicial interpretation is normally most common form of the interpretation by courts, whose task is to apply the law. But the administrative interpretation immediately affects the case immensely, and it is accepted as a legal effect as long as it is challenged by the administrative or legal procedure, which takes a long time. Administrative interpretation serves a practical code of conduct until a court of ruling is made, where when there is an administrative interpretation from a competent ministry, citizens tend to act based on it, unless there's a special circumstances. The definition of the serious injury again, some discussion about whether the provision in Annex 13 within the definition of serious injury, typically Article the Bravo, result in a fracture of any bones except simple fracture of fingers, toes, and nose. Is it enumerative, or illustrative? You may have heard the terms enumerative or illustrative. I compare a little bit of difference with the ICAO definition and the Korean safety law. It's seemingly a little bit different. And enumerative provision typically lists a specific example, while illustrative provision offer example to clarify the broader concepts. Understanding the intent behind this specific provision could be helpful in ensuring a consistent interpretation. Perhaps we could delve deeper into the relevant legal context and overall purpose of the definition to determine the most appropriate interpretation. Defining serious injury with the aviation safety and security can be a complex task, while universally perfect definitions may be almost improbable. Additionally, safety professionals may not always have access to complete medical information, which can introduce elements of uncertainty. And furthermore, individual factors like recovery timelines can vary significantly. This complexity highlights the importance of the ongoing discussion on how to best define serious injury within the aviation safety framework. By acknowledging these challenges and fostering collaboration with medical professionals and legal experts, we can strive towards a definition that is more objective, reflects current medical understanding, and ultimately serves the best interest of aviation safety. As an ongoing effort, Korean Air, these concerns regarding clarifying the definition have been addressed in international conferences with lots of consensus of the participants, such as Fly Safe Foundation International Aviation Safety Summit year 2023 in Paris, and ICAO Regional Aviation Safety Group Pan America, RASPA, in Santo Domingo year 2023. And specifically, these concerns were delivered to the ICAO AIG, Accident Investigation Group sector directly, and I was informed that this will be introduced to the panel group discussion. There is some process to discuss. To recap two key points that I present today, the definition of the serious injury within ICAO Annex 13 is a critical element, is aviation safety investigation and plays a vital role in preventing accidents. However, there's some room for improvement. We've explored some of the potential area of the consideration, such as redefining the definition to enhance the clarity and consistency, and providing further clarification on the interpretation of the specific example, such as fractures, and developing additional guidance for the administrative interpretation. And there are several steps that we can take to address these challenges associated with the current definition of serious injury. We need to establish clear and specific criteria for what constitutes a serious injury, typically considering medical expertise, I would say. And additionally, ICAO-centered international collaboration is crucial to develop the globally accepted definitions. And finally, we would continuously evaluate the effectiveness of the definition and make adjustments as needed to ensure its continued relevance in promoting aviation safety. That is the nature of the law regulating nature. And reality changes, it should draw regulation change. In conclusion, overall conclusion, clarifying definition of serious injury is essential for protecting the lives of passengers and crews, and even sustainability of the aviation itself. And clear and harmonized definition of the serious injury are needed now at the national and international levels. Continuous efforts and cooperation are required to strengthen safety and security measures to prevent serious injury in aviation. That makes aviation even safer. And ladies and gentlemen, this concludes my presentation, and I want to express my gratitude for your attention today. And let's continue to work, help each other, to share the knowledge and value. And lastly, it's just such a privilege again to participate in this kind of important seminar, and I look forward to working together in the future. Thank you very much indeed, and wish you have a great afternoon. Thank you very much.
Thank you, Captain Bae. So as promised, we are going to have a coffee break for 10 minutes. Remember, we have another coffee break, so make it quick. So in 10 minutes, I'll see you later. Thank you.
Yes, welcome back everyone. We are to resume our second session on aviation safety and security here at 2024 ICAO Legal Seminar Day 1. We have listened to the presentation brought by Mr. Venua Verhagen and also Mr. Kang Won Bae. And we have two more presenters to go, and afterwards we'll be moving on with our discussions. So if you have any questions, please hold them until the end of the session. And I will now pass on the mic once again to our moderator, Professor Lee.
Thank you. Welcome back, everyone. So for the next 55 minutes, we will discuss role of regional safety oversight organization in supporting states. So we have two speakers with that topic. I'll also make sure that we have a Q&A session at the end of this session too. So our third speaker is Captain Denise Gaindong. Captain Gaindong is Deputy Director of Monitoring, Analysis, and Coordination in ICAO Air Navigation Bureau. Captain Gaindong joined ICAO in 2018, and after a long career at Transport Canada Civil Aviation, where he was Director General of Civil Aviation. At ICAO A&B, he oversees all continuous monitoring and oversight activity. Captain, the floor is yours.
Good afternoon, Vice Minister Beck, Secretary General, Director General of Civil Aviation, distinguished guests and colleagues. As you are well aware, supporting the function of a CA is complex in the area and as well financially demanding for several states. For the last 30 years, some states are grouping themselves to try to improve their capacity and efficiencies in discharging their safety obligation by combining resources. We call them RSOs. The Interstate Aviation Committee, commonly known as AIC, first RSO and was established in 1991 and included 12 of the former Soviet Union member states. The number of RSOs since and their sister regional accident investigation organization, what we call the RAIOs, have continued to grow and are now supporting more and more states. RSOs are well recognized, and as such, ICAO Assembly Resolution A40-6 states in part, recalling the member states are responsible for implementing ICAO standards and may, in this respect, decide on a voluntary basis to delegate certain functions to RSOs, and that, when applicable, the world state should be read to include RSOs. But obviously, RSOs are not all created equal and have different structure, governance mechanism, and obviously some are more complex and offer more service than others. There are a multitude of RSOs, and they are listed in alphabetical order on this slide and the next two slides. You will see they cover many areas of the world, but are more concentrated where there is needs to support actively states which are challenged with resource and capacity. We have as well other which are covering well-developed aviation systems and perform complex activities. 6 are covering Africa. AXA covers Central America. We have EASA that covers European Union and is the most mature organization and offer a suite of complex services. The Interstate Aviation Community, which was discussed earlier at the beginning of the presentation, offers safety but as well investigation services. CASOS covers part of the Caribbean. PASO covers a very much needed support for several small Pacific states. Additionally, and finally, we have the just formed RSO MENA that was created a few months ago in Saudi Arabia. The organization will be based in the UAE and covers several states from the Maghreb and as well Eastern Africa and the Middle East. ICAO is establishing contact with them at present, so to bring them along in our cooperative platforms. Currently, close to 130 states are members of an RSO, as shown on the map above. The map does not show MENA coming to life, but its formation now almost all of African states are covered by supportive RSO, which is very positive. Regional cooperation is not only in safety oversight, but as well have specialized organization in incident and accident investigation, which are called RAIOs. 5 of such organizations exist, which cover part of South America. There is one in Banjul Accord Group named Bagaya, one in Europe in Cassia, and finally IAC in Russia. So far, a total 64 states under the support of an RAIO. So just back to this slide to show you what we have around the world right now at present, and it's still evolving. So why an RSO? Some states may have less than ideal oversight capabilities, difficulty providing financial or human resources, lack of qualified personnel, difficulty ensuring competency of their technical staff, low level of activity to warrant full-time personnel attached to the civil aviation organization, or some states has capacity to leverage their expertise and resources to support their neighbor states and effectively improve aviation safety on transborder flights transporting their citizens. A good example of this in the Pacific is New Zealand that is supporting PASO. The defining characteristics that are common to all RSOs lie in their uniform mandate, objective, and purpose. Low level of activities coupled with competing demands for state resources may result in inadequate allocation of resource for a state aviation safety oversight or investigative activities and program. Additionally, innovation and emergence of new industry entrants, new technology also require additional resources and expertise which may not be readily available within the states can be provided by an RSO. The function being conducted by RSOs have grown from advisory or coordination to surveillance and even certification. ICAO has defined 3 levels of RSOs as such. Level 1, RSO provides advisory and coordination functions such as advising states with regulation, development of guidance material, and coordinating pools of experts or inspectors. Level 2 RSOs provide operational assistance functions such as developing regulation, training inspectors, and conducting inspection or investigation. RSOs such as AXA in Central America or Bagasso in West Africa do this. Level 3 RSOs includes level 2 function plus certifying function, issuance of regulation, and authority to issue, amend or revoke licenses, authorizations, and approvals. For example, EASA and IAC. These last 2 are the most complex RSOs we have. There are several reasons states may join or form an RSO. However, the most common reason is to assist in effective safety oversight. RSOs can provide expert advisory and consultative service for effective safety oversight. They share best practices. They issue technical assistance. They execute safety oversight function on behalf of member states. As well, they can support or provide a level playing field between certificate holders of different countries by promoting a common set of aviation safety requirements, oversight, and standardized application of rules. During the first few weeks of the COVID-19 pandemic, we saw RSOs coordinate their member states' response on differences, implementation of harmonized measures to mitigate the effect of the COVID-19 pandemic, and maintain the safety performance at regional and global levels. Additionally, RSOs assist states in preparation of USOP audits, but most importantly, assist their state on correction of SSCs and deficiencies. Furthermore, some RSOs have developed cooperative inspectorate schemes where qualified regional inspectors are used in a pool of inspectors within the region. In regard to funding of RSOs, funding source may include member states and regional economic communities' contribution, donation, and/or grants from international donor organizations. Specific user fees and charge ultimately through the collection of an air safety charge. For example, 3 states, Gambia, Ghana, and Sierra Leone, out of the 7 Bagasso member states have adopted the safety charge in their legislation, out of which 1 state, Ghana, has implemented. Guinea, Liberia, and Sierra Leone live by charge through their flight information region, their FIR. At ICAO, the Regional Safety Cooperation Unit facilitates regional cooperation through 4 areas. First, the cooperative platform brings together about 14 RSOs and 5 RAIOs and investigation cooperation mechanism to strengthen them, share best practices, and build partnership. Second, we are working actively on the voluntary assessment program of RSOs and RAIOs, which assess qualification capability using tools similar to those of the USOP program. The program right now is going through substantive change from GASOS to the RSOs, RAIOs assessment program called RRAP. We're about to publish the newly amended 3rd edition of the manual Doc 9734 Part B, the establishment and management of a regional safety oversight organization, due to results of studies conducted and development since the last edition that was published in 2011. The first edition of the RSOs and RAIO assessment program, the RAP Manual Doc 10143, is being developed at present. Under communication and training, the last area, we provide training, workshop, safety promotion of RSOs, present papers, and conduct studies on RSOs, RAIOs, and have held international conference on RSOs, such as the virtual ICAO EASA, Strengthening Regional Cooperation Conference in 2022, and the recently completed second RSO Forum in Nairobi in October 2023. In more details of those 4 areas, RSO Cooperative Platform core functions are to assist and strengthen RSOs, and the platform carries this with an exchange of information and best practices, coordination and sharing of manuals, communication and ID exchange, networking, but as well, and very importantly, a byproduct of the RSO Cooperative Platform is a feedback loop to ICAO on its program, needed improvement on implementation strategies, guidance material, and etc. In regard to the evolution of GASOS to the RSO RAIO's assessment program, some of you can probably recall that the global the global strategy for GASOS was adopted at the RSO Forum in Eswatini in 2017. A year later, in 2018, the ENG Conference 13 limited GASOS to RSOs, RAIOs, and to assess RSOs and RAIOs at level 1 and 2 only. The level 3 organizations, such as EASA, are under the evaluation of the USOP, since some of the service of this organization are at the level and scope of a state. In 2019, the 40th Assembly endorsed the GASOS program after it was approved by the Council, and in 2024, the GASOS scope was changed and renamed RRAP. For the RAP, which is an important transformation from the initial vision of GASOS, it is now a voluntary program and not an audit. It uses modified USOP tools and its proven methodology. It is under a cost recovery mechanism, and it assesses capabilities, provides an assessment core, identifies gaps, and finally suggests improvement to the organization. For guidance material, we see different levels of maturity in RSO, obviously, from organizations with 20, 30 years of experience to the recently established RSOs or other mechanisms with different dynamics. Those asymmetries oblige us to recognize the relevance of this type of cooperation at different stages of development, so to maximize our efficiency in developing guidance material that could be applicable for newcomers, but as well for olders and more mature organizations. And a new guidance document on RAP, which was created by a group of experts and finalized within the Air Navigation Bureau, we are targeting end of 2024 for publication. And finally, on the last area, and to conclude, the support to RSOs by ICAO, the communication and training includes RSO forums, conference, workshop, training through the RSO Cooperative Platform, plan online training for RAP assessors, as well as updating relevant ICAO documents and policy on regional safety cooperation. And in conclusion, we obviously see the benefit of RSO as one of the pillars of implementation support that ICAO can offer. ICAO provides a safety framework toolbox which consists of SARPs, guidance material, auditing of states through the USOP, but actually, indeed, a well-organized and active support of RSOs and RSOs is a strong addition to the suite of tools ICAO offers. It provides states with less means to better achieve safety implementation of ICAO requirements, and in turn, an increase in safety level across the region and in the world. I want to thank you for your attention.
Thank you. Based on your on-time performance, I can see that you are captain. So our last speaker is Mr. David Waller. David is EASA, European Union Aviation Safety Agency, EASA representative in Singapore. He has worked for EASA, he joined EASA in 2004 and has held various positions in technical training, international cooperation, and strategy development. David is originally from Britain. So several years back, when Brexit was such a hot topic, I asked him whether he's going to be okay after Brexit at EASA. He told me I'm also Irish. So please welcome British and Irish David.
Thank you very much, June. I'm very much a fake Irishman, not a real Irishman, so I make no pretenses there. So, dear distinguished hosts, dear distinguished guests, thank you very much for having me. I think Denis gave a very good presentation on RSOOs there, so it's left to me just to kind of color in the subject with a practical example. EASA was mentioned, we are one such organization, an RSOO. But before I continue on EASA, before I say any more about RSOOs, I think it's worth taking a step back and looking at the benefits of regionalization as a whole, before we just focus on organizations that maybe can support that in terms of safety. So the benefits of regionalization don't just include safety. You can see really they affect the full spectrum of stakeholders involved. The benefits include a lot of economic, which is of course a very powerful driver for making things happen as resources are always scarce. There are clear benefits for industry, which are perhaps not really clearly mentioned enough on this slide, such as a more level playing field, more operational certainty due to the similar rules between states, and, for example, a single approval process instead of multiple audits, cutting down on duplicated oversight. On that last point there, I don't know how much you can actually read what's in the slide on the partners. The EU, as a region, loves dialogues with other regions, particularly ASEAN, for example, and also with its fellow RSOOs. And we channel a lot of technical assistance via RSOOs. And I'll speak more about that in a second. So a bit more background. As Denis mentioned, RSOOs have been in existence for more than 30 years. And partially because of their independent evolution to each other, in other words, they evolved apart, there are various institutional setups. So for example, there's EASA with a very solid, let's say, legal basis. At maybe more the other end of the spectrum, and I'm not even sure it can be classified as an RSOO, not quite even level 1. There are organizations such as SRVSOP in South America, which don't have a specific legal personality. They operate more as an ICAO program, but support states nonetheless. But since every region is different, with different political structures and needs, I think this variety makes sense. ICAO recognized the benefits of RSOOs quite early up. So it issued, as Denis presented earlier, the Safety Oversight Manual, document 9734B in 2006. I think that should have been another one to add to the Benoit's milestone list. And that was extremely helpful because I think it helps solve something which looks like a contradiction, because the Chicago Convention considers states not really regional organizations. But the two aren't mutually exclusive or incompatible, as we'll mention in a second. So obviously being an RSOO, EASA has been very keen to work with ICAO to help drive the RSOO concept forward. You can see some forums here, some of which were mentioned earlier. The 2017 forum in Eswatini paved the way for the RSOO collaborative platform and the concept of the Global Aviation Safety Oversight System that Denis mentioned, GASOS, the assessment mechanism for regional organizations based on USOC principles. In 2019, the Assembly passed resolution A46. That's on regional cooperation and assistance to resolve safety deficiencies, establishing priorities and setting measurable targets. The 2022 virtual conference that you see mentioned there, that built on the ICAO high-level conference on COVID-19 in 2021, which also considered proposals on how to strengthen various forms of regional cooperation and proposed recommendations addressed to states and ICAO. There's the 2023 forum that Denis mentioned, which made a number of recommendations for ICAO states, RSOs, and industry. And although not mentioned there, but it's also something EASA supports. We have some long-term secondments of experts to the ICAO Secretariat to support their work on RSOs. So now I'd like to talk about EASA, but it is an unusual RSOO. As Denis mentioned, it's level 3. It's quite advanced. But a lot of, I think, what I want to say about EASA, yes, we're kind of a special case. We have this supranational framework of the European Union to hang off. That's very useful, but it's not essential. Actually, there was a regional safety oversight organization in Europe before EASA came along. So it was the Joint Aviation Authorities. And I think that illustrates a lot of the principles that I kind of touched on earlier, because it's the motive for it, what made that happen, are in line with what I mentioned earlier. So I talked about economic drivers. Principally, it was a little bit, the pressure came from industry. Companies such as Airbus and Rolls-Royce, they didn't enjoy having to spend millions of euros on type certification of their products in every single European state. It makes much more sense to just do it once. So they created the Joint Aviation Authorities, which operated under something called the Cyprus Agreements. So Europe worked collectively together before EASA was ever born. Nonetheless, a lot of what EASA does, I'm wondering what's going on with my slides. A lot of what EASA does, so yes, we benefit from that supernatural framework, but we probably do a lot of that even if it didn't exist. For those of you who have not been to EASA, it's that building on the right there, just by the river. So we're very small, actually. I mean, I think 800 is probably a lot smaller or a lot fewer people in your respective organizations, but we have the luxury of really only focusing on safety and more recently, sustainability. So in very high level, we kind of carry out 4 tasks, which you can see in each of the corners there. And in the middle is our scope in terms of topics and themes. So certificates and approvals, EU rules. So the principle being 1 certificate, 1 approval is good for all of Europe. EU rules and guidance material. So it's 1 set of rules for all of Europe. So instant harmonization. Member state inspections. So we check to make sure that the rules are applied in the same way in each European member state. And then we also have an international cooperation function which provides support, particularly through RSOOs, as I mentioned before. So in more detail, so to use the nomenclature described by Denis earlier, a lot of what we do is at level 1, but we have this ability to carry out tasks on behalf of the member states based on the Treaty of the Functioning of the European Union. This is notified to ICAO by the member states, but it's important to point out that EASA or EU member states retain their international responsibilities as ICAO members. It's individual member states that vote in ICAO, so it's not the EU or EASA. So yeah, examples of our work, as I mentioned, certification of aeronautical products, approval of design organizations, certification of pan-European operators, like Airbus, for example, which is present across many European countries. Again, the logic is that it has to make sense to do it at regional level. Otherwise, it's done by the member states. So in fact, actually the bulk of work is done by member states, and it's only these examples where centralization makes sense that is done by EASA. This shows a lot of the other RSOOs worldwide that we support. So principally here you see Africa, Latin America, and the Caribbean. In Asia, although ASEAN is not an RSOO, we work with ASEAN to support their ambitions for regional integration under the Kuala Lumpur Transport Strategic Plan. And we similarly work with South Asia under the framework of SAARC to support the South Asia Regional Initiative there. So the conundrum, how does that work within the states-orientated framework of the ICAO, the Chicago Convention? I'm not sure how readable that is, but yeah, I mean, it sets out the kind of conditions. So this refers to rendering each other's licenses valid, subject to certain provisions. And within the notes here, the text, it explains that under Note 2, for example, common licensing regulations refer to a common licensing regulatory framework that is legally binding and directly applicable to contracting party to the agreement, recognizing the automatic validation process. It carries on, a regional aviation safety body can develop and maintain these common regulations for its member states. So this amendment facilitated or facilitates the operation of RSOOs under the state-orientated framework of the Chicago Convention. Some further benefits of RSOOs, what are their advantages? So the first point there, you see that they know their states well. I guess that kind of follows the logic of the ICAO regional offices in a way which, because they're closer to their states, they know them more intimately, they're able to support them better in their setup and functioning. The second point on synergy and coordination, I think that really can't be understated. Any work lost in coordination, because sometimes coordination can be quite complex, is more than made up for the fact that now you don't have to reinvent the wheel. What's good for one state can be used by all states. The same logic is reflected in the sharing and simultaneous transmission of information. And RSOOs also allow the creation of regional systems. So yeah, examples there, RAP inspections, occurrence reporting. So if nothing else, the economy of scale, the increased sample size helps you build up a more detailed and therefore more accurate picture, improving safety intelligence. And some very last takeaways before I close. So hopefully most of these echo points I've already made. So in developing an RSOO, it has to be driven by what makes sense. It's not something you just do for the the sake of it. The benefits, the economic drivers, for example, should be there to drive forward the integration. Otherwise, you won't get that political buy-in, you won't get that industry buy-in, and so forth. There's no one-size-fits-all solution. So yes, EASA or Europe, we do it one way, and we absolutely do not say, when we work with other RSOs in the world, that's the way you should do it. Each region is different, and solutions have to be tailored to the unique specificities of each region. And lastly, and I leave it, it's last, but unfortunately, certainly not least, it is a reality. A key challenge for RSOs that we all have to work with is the one of sustainable funding, always a key challenge. So that's it from me. Thank you very much for your attention. It was a pleasure to be able to speak to you, and I now hand back to June for the question and answer session.
Great. Thank you, David, and also thank you all the panelists for your really on-time performance so that we can have 20-minute Q&A session. So what I'm going to do is I'm going to pose some questions to each speaker, and after my questions, we also receive some questions from the floor, so be prepared. Maybe raise your hand. I mean, I'm not going to call you, but right after our discussion, we are going to take questions from the floor. So my first question to Benoit is that, so you talked about the difference between standard and recommended practice in terms of reporting. So under Article 37, 38, for standard, state need to report its departure. And you also talked about the possibility of having the reporting system on recommended practice. So I think ideally it's nice to have that reporting system, even though we don't have such law in the Chicago Convention. Can you explain a little bit more about that? 1 or 2 minutes, please.
Thank you very much, June, for this question. I'm very fond of recommended practices, and I think they are neglected a bit too much, just because they don't have the same legal force as standards. But they're extremely important. They're extremely important. First, it's obvious from the fact that they are adopted by the Council. They're subject to the two-thirds adoption procedure in the Council. Why are they important? Because they are actually the preliminary stage before a requirement could become a standard. It's a test phase. And it's why it's very important to have a feedback about the implementation, because, look, imagine a recommended practice that is not followed by nobody, that nobody likes, but nobody reports about it. The reaction we may have at headquarters in secretariat is, yeah, great, no differences filed. So it's fantastic. So let's go for an upgrade and let's go to the Council for adopting this requirement as a standard. That's why the Assembly complemented Article 38. And the Assembly decided to ask the states to consider filing differences not only from standards, but also from recommended practices. But there is a second reason. I mentioned that the Assembly also, and the Annex 15 actually, says that the states are expected to publish in their aeronautical information publications such differences from SARBs and PANs, so meaning including recommended practices, that would have a significant impact for safety. The only problem in terms of practical difficulties is that the annex does not qualify or define was it significant in terms of safety. So it's left to the discretion, to the consideration of each state. And look, in order to have a real good overview of the subject, then it's better if we can rely on the filing of differences. Thank you.
Thank you, thank you. So my question to Captain Baer. So in your presentation, you suggest that new definition of serious injury. But those who are studying aviation law, you probably know that a lot of conventions have a problem of having right definition, not only Chicago Convention on one axis, Montreal Convention as example, accident, bodily injury, delay. These are terms we can never have perfect definition. So my question to you is that your suggestion, isn't it impossible dream to have a right, perfect definition?
Thank you for the question. First of all, I'm not talking about the exact suggestion, words to words. This is the definition. We have to move on. Because as you point out, it's almost improbable to come down to the all of the definition that is related to the aviation safety. Especially today, I talked about serious injury and then the way forward, how we move up with this kind of terms and definition that I would say, I think it's a law or a nature. There's a certain process move on, which is, we call it an evolution. Serious injury part of the definition was, as I point out, was first to come out into effect in 1951. And ever since, there were 12 amendments of an ICAO and 13 improvements. And then there were lots of consideration as stepping forward at these 12 amendments. But direct point to the serious injury part of the ICAO next consideration was lastly in 1988. And then as you said, then, there are environmental changes and technical changes, and then every circumstance on aviation changes. But I believe we are a little bit, maybe we made maybe from the beginning too perfect definition, I would say. But as situation changes, we have to look in very carefully with that. And as I point out that when something changes, always there is a reason. First, if it sounds rational and reasonable and it's very plausible, that's the way we go forward. Or it is not easy. You think it is the perfect moment we have to go for. It's not easy. Practically speaking, we have to look at our neighbor, what they are doing. If they advance, they're going forward. We don't know why, but there is a reason always. And then that's the point I'm talking about. We consider a little bit carefully with our other transportation sectors, considering about their serious, because they have for example, the ground transportation, there are so many accidents, so many things considering the definition of serious injury, because it has not only the protection of those passenger and victims, but also its litigations and the cases. Okay. So we have to take a look at it very seriously.
Understood. Thanks. So question to Captain Ging-dong. I actually had a couple of questions. I mean, really, I wish I had more time. I mean, I wish I had vending machines. I can put my coin. I can save on my time, but time is limited. So question I received from my friend, knowing that you are coming to this floor, is that how does COVID-19, it's really remarkable that we never talked about COVID-19. It's really nice that we never talked about COVID-19 in this legal seminar. But the question I'm going to ask is that how does COVID-19 type crisis, how can our suits can help this kind of global crisis?
Thank you. Well, first of all, it was very exciting for all of us, obviously. It was extremely challenging. We saw a different approach and different measures being taken around the world. We saw some fantastic opportunity coming out of Europe and the Europeans through EASA trying to support actually the resume of operation in complex areas. But we had as well some states which had not very much means that were able to their RSOs actually to work through, even if they were level 1 or level 2 actually organization that were able to pull their IDs together. At the same time, what was interesting is the cooperative platform that ICAO was offering to the RSOs was coming together to try to help all those RSOs to have discussions and share best practices, tools, and at the same time to be able to be quite helpful in transmitting information and the best practices. So it was certainly highly challenging, but I think that is as with anything. I mean, cooperation between people brings better benefit and as well additional capacity to be able to support some challenges. So thank you very much.
Okay, so my final question, so again, after this session, we're going to receive questions from the floor. So if you have any question, please raise your hand. Then microphone will be ready. So question to David. In the last slide, you talked about, quote unquote, you don't need supranational structure like EU to make it work. Yeah, that's what you said. So in terms of any types of regional integration in aviation, EU has been named as the best example. At the same time, we know that EU is highly exceptional. So my question to you is that what kind of lesson you can provide to those who are considering ARSUS?
I think it goes back to what I was saying about the needs, a kind of needs-driven approach. Actually, I think COVID is a very good example. So EASA developed the, it was called the EASA ECDC Aviation Health Safety Protocol. We had absolutely no competence in health before that, EASA, I mean. So we had no legal basis to issue this document, which was used by many member states and turned into law by many member states, which Europe found extremely useful. Certainly European industry found very useful because in each country, suddenly there was a harmonized approach. So it was the fact that we provided a platform by which the member states could get together, could get to agree on a kind of common set of rules. Each member state knew that EASA had no legal power, or the EU had no legal power to impose that set of rules. But as it made sense, each state was happy to kind of incorporate that, digest that within its national system. So in short, where there's a will, there's a way. RSOOs, just the simple fact of providing cooperation platform between member states are extremely powerful, and harmonization and all these other benefits flow out of that as a natural consequence.
Thank you. All right, so we have about 10 minutes for Q&A. Anyone who has a question, please raise your hand.
Thank you, Mr. Moderator. I'm Soyeon Park from Mullet, and I'm looking after aviation safety data collected by reporting systems or other data collection system in Korea. And I am looking after the state safety program, so which means I am in safety management area. So I have a question to Captain Bae. A turbulence injury is actually one of the most frequent safety issues in Korea as well. Can you elaborate a little bit more on the implication or possible impact of redefining the definition of serious injuries in the context of aviation safety? Thank you.
Thank you very much, Ms. Park, and it's a very important question. As I said before, this is nowadays the weather pattern change, and it connects with lots of in-flight turbulence-related injury happens, and then international aviation safety, it's tried to address the question and how to deal with the situation. To answer your question, redefinition or clarifying the definition of serious injury is very important because, first of all, I can say philosophical reason. First, that is right to move forward because if there is no perfect definition that fits from what we are, it's not going to work. So that's number one, the philosophical answer. Number two, I would say a pragmatical answer. Ladies and gentlemen, it's the accident. I'm talking about accidents. That seriousness definition, draw the lines coming over, whether this becomes an accident or it's just events or incident. When it comes to the individual operator, having a one accident, it's a big story. You never know how big burden individual operator will face with having an accident. If they have a fatal, yes, they deserve it, I would say. But let's say you have some stress fracture, then by the definition, it becomes an accident. Now it's a different story. Let's moving on to the state level. They are responsible for the maintaining their state's rate of a certain level of safety. Once an individual operator within the reason of their state level, if they have a 1 or 2 accident, now it's also they are failing with their objectivity of the maintaining certain level of safety with not the proper definition. These things we have to consider very carefully. Moving on to the international level. International level, this is the data management. We have to have objective data to compare different reasons as to why this has happened, how to address the situation. So to have a very good definition of the serious injury is very important about all different stakeholders. I hope that this is enough answer for you.
Thank you. Next question, please.
Good afternoon. Thank you very much for a very informative presentation to the panel. My question is with regards to the recommended practices. So it is said that recommended practices by nature are not meant to be binding, whereas in some instances we are expected as member states to comply with them in terms of there are protocol questions that are derived from the recommended practices. Equally, we are supposed to file differences. My question is this area not requiring certainty, does it not create problems, not only for the member states, but also for ICAO in its responsibility of monitoring implementations of the said recommended practices? More especially when we do not have a definition of what is a significant safety concern. Thank you.
Thank you for the question. Actually, I think I could perhaps offer a reply, and part of it maybe Denis on the safety oversight perspective can complete and correct me if needed. I used to be a safety oversight auditor. So what I can tell you is that, yes, we have a comprehensive review of how a global safety system works in a state. And we'll certainly check what is the degree of implementation of all the ICAO rules, including the recommended practices. However, they are not legally binding, so Denis will perhaps expand on that, but we will certainly not, for example, issue a finding because there would be a lack of implementation of a recommended practice. Now, I'd like to come back to what you said about significant. There is a difference between reporting in the IP on these differences that are significant for safety and what ICAO reports as significant safety concern. That's not the same at all. So yes, the IP says that to report on these differences from SAPs and PANs that have an impact on safety, and it's not defined by ICAO. But when we look at how states often implement their obligations in transcribing the ICAO rules into their laws, we see that often a state might not necessarily make a difference between standards and recommended practice. They may have the same legislative weight for these rules in their own laws. So that can happen. It's why it's important to have this reporting on the differences. I'm not sure whether Denis wished to complete.
Merci.
Thank you.
Thank you, Benoit. Thank you for the question as well. Basically, is when and I'm going to go through the USO program, which is another one of my portfolio here. When I go and check the states in regards to discharging their responsibility to looking at their system through protocol questions. And basically what we're looking at, if it indeed is the states are meeting the requirements or not, and if they're not, have they filed a difference? And from there, basically, we have a single report to a state that provides them more or less the health card to the DGCAs of how their system is performing. We have obviously a humongous database of differences, of which standards being applied or not in each of the states, recommended practices, and so on and so forth. But what we have to realize is that there's close to 12,000 standards through the annexes. So it's impossible to go and through a comprehensive audit in a reasonable amount of time with 7 or 8 inspectors looking at the CAAs if we would have to look at all of the applicable standards and recommended practices. So the usual program is built more or less as a system base. So we're asking questions to states in regards, how do you discharge your responsibility? And we're trained auditors, assessors, basically, of the system. We're able to make an educated evaluation through criteria if indeed a state is meeting or not the requirements. So that's one thing. The second thing I want to say is that ICAO is upgrading its capacity right now and being able to look at all the data that we have, to be able to understand better where we have meeting the requirements or not in the applicable standards, which I think is going to yield quite a lot more substance, I guess, to the program, and as well to help us in regards to where we should be able to invest more resources and implementation, help other states. Hopefully I've helped you with that question, Benoit. Thank you.
Okay, thank you so much. So I think I'd like to conclude this session. If you have any burning question, you can talk to our panelists during our coffee break. As a teacher, I can see that sometimes body is here, soul is away. But audience, I can feel that your body is here, your soul is here. I really like the level of concentration, level of attention. First of all, I really appreciate that. Really thank you for our panelists for such an engaging, interesting, really informative session. Please join me in the panel for this great session. Thank you.
Yes, thank you very much. That ends our second session here at 2024 ICAO Legal Seminar. Well, we have ended the second session and we will have the coffee break for about 30 minutes. But please remember that we will be having the open debate with the next generation of aviation professionals held under the title of Balancing Innovation and Regulation, the Future of Sustainable Skies in Emerald Room. And also we have the welcome dinner that will be held 6 o'clock today here once again. So the dinner will include the performances as well as a lucky draw. So please make sure that you will join with us once again at 6 o'clock here in this room. And lastly, we have the city walking tour to enjoy the Seoul before and after the seminar by walking around the event venue. Well, however, this was a first come, first served for 30 people and it's full booked. However, I'm sure that there might be some cancellations in the meantime. So if you're interested, please visit the registration desk and see if there is any vacancy ready for you. So if you have registered, please make sure that you will gather around the lobby and enjoy the site walking tour with us. Having said that, we'll see you all once again after the coffee break. Thank you very much.